Day after Friday. Follow.
No, tomorrow is Friday.
4 years.
Lordship, after a week, I understand the lot of things matter. Yes.
20. Yes.
Lordship? Yes, yes, yes. I'm not with that, John. My land is
Of like
Lordship, the week. After the test, and April
of like
of like
lucky testing matter related to equals divide by the shared by property. Some agency is there, but technical. No, it is not cancelled. That is, you are not supposed to protect that. Only we need equals divide. The divide by equals divide. The divide by which we distribute the KTS items. This is a lot. Because item number 4 and 5 matter. A lot time for the component number 7 for the 4 method. Some difficulties method. I've taken concept of the traditional DK Purva method. No, no, a lot direction number 5 direction. Can you see your first visit? Can you see your first visit? First visit. The conceptual. Hello. Hello. May I say? मतलब on behalf of Linux in your company, Mr. Cam this Linux, I beg to mention item number 16. मतलब is out of station. Thank you, madam. Yes, मतलब thank you. 9 to 5. Public. Wait, please, just a lot. Milo, I beg to mention item number 1 by. It's a concern of the other side, Milo. In your council, Milo, Mr. A. Savalai, Madam. Yes, sir. Milo, which a concern. HP Kuala, Madam. Kuala. Right.
please do not. I beg to mention item for district court. Bone matter. For admission on the 20th of March, Lordship is a contractual yes, apply. Yes, Mr. Lordship. Thank you. And actually, pay for discount and urgent matter connected to item 13 has been listed tomorrow.
Please do not. Matter. It's a high for state vacation. Meetings has been completed your class is not 12th of February. When your lordship had directed that it be listed after a week here. And I did on Monday. Madam, the time says for listing of it. It is another more of a regarding excise and that new method. The next is for listing of the method and the party entire process was I participated. I was the whole method. We are shown the whole method, pending method. Okay. Okay.
Thank you, Your Lordship. I mention item number 14. To the consent of the abstract matter may be taken after we tender related matter. Minor mineral. My lord, for 5 years. The period 5 year term has been expired. My lord, I yes, my name is not there in this case. I'm appearing on behalf of MJ Bhatt. My name is not there in this case. I'm appearing on behalf of my senior, MJ Bhatt. I took the consent. The, the other side. Yes, yes, yes. But during the pendency of street petition, our ground, is- that's the only ground. During the pendency of the street petition, the tender period was expired. My senior will page number 10, my my senior will do that. I is in the answer, is in the answer. 23. Item number 1.
See, some tourism development corporation also is fighting with your conflict. Yes, L1 that is there, but I'm on the technical evaluation. Yes,
Yes, I have been disqualified. I was given the lesser marks than the respondent number 4 and another one. Now, Lordship, in that case, Lordship, the big document, some big documents, whatever they submitted, they were not authentic, which is the big documents submitted by the respondent number 4 and us, not authentic and not some invalid. Yes, my, that is my case. Annexer 7. Lordship, Annexer 7. Annexer, first I'm showing my documents. Annexer C. The documents which I'm page 142. Annexer 6, your Lordship. This is my documents. The first 142. Annexer 6, Lordship. This is network certificate. And this network certificate I submitted as per requirement, as per criteria stipulated in the NIT, Lordship. And the below UDIN number is there. UDIN, unique document identification number. That is mandatory, Lordship. If the turnover exceeds for the year more than 1 crore, that is mandatory. Lordship. No, in any document pertaining to any assessment, your Lordship, that UDIN will accompany. The UDIN has to be incorporated. Now that is fine. I am showing my documents. Now I will show your Lordship the documents of respondent number 4. 151. Your Lordship. The ground is not assigned, only marks was given. Lordship may have a look on the technical evaluation. 151, the documents that is submitted by the respondent number 4. Asset liabilities, that is network certificate, that is on 31/3/2022. Whereas he submitted his bid on 2/11/2023. Back 1 year, 7 months later. Much back from the date of submission. And without deal. And apart from that, I'm showing you the turnover certificate. Annexer 153. Page number 153. The turnover certificate, he submitted turnover certificates at serial number 2 for the year financial year 2018 and 19. Yes, 9 crore 76 lakhs 63,000 so and so. And he also filed another one that is at page 155. Your Lordship will find. H4, serial number 4, your Lordship. For 2018 and 19 similar. Here the amount is different. 1 crore 55 lakhs 84,467 euro. Here the amount is reflected differently. And Lordship here in page 153, that is 9 crore 76 lakhs. For that financial year, 2 different amounts, your Lordship. These are mismatched. That is another document, and that too without the unique document identification number. And apart from that, your Lordship, this is he has not submitted the auditor's report, which is the stipulated criteria of the NIT. May I take your Lordship to the NIT? Page it starts from page 31, the relevant you will find. Lordship will find at page 39. Page 39, your Lordship. plus 4.3. It starts from 4.3 conditions are given. Page 39, copies of original documents defining the constitution of legal status, place registration. This is registration certificate of the contractor. Next, Lordship total monetary value of construction work so and so, major items, qualification and experience. Clause 5, Lordship reports on the financial standing of the bidder, such as profit and loss statements and auditor's report. He didn't submit it. Or the auditor's report. And the financial turnover certificate so far submitted by him were a mismatch. The amount in two different certificates for the year 18-19 were different. And so far, clause 6C, the bidders who submit net worth certificate, that so far what I have already referred to your also. That is 40. 40. Roman 6, your lordship. Oh, clause, sorry, Roman 6. Roman 6C. The bidder should submit net worth certificate of minimum 10% of estimate cost is by the certified chartered account. And to qualify your lordship, one more condition is there, 4.5. In the same page, the bidder should have average annual financial turnover, estimated cost, construction of work, so and so. The balance should be duly audited by chartered accountant. Bidder must submit audited balance sheet. In 30% was there, whatever his document showed. But the thing is that the invalid one. That yes, my lord, turnover certificate that was mismatched. And lordship, apart from that, I am showing you another paper. 150 lordship is turned to page 157 euros. 157. That is the invalid registration certificate filed by one Buragukai lordship, who secured higher marks than the petitioner. This is the invalid certificate lordship may peruse. The registration of the following contractor hereby renewed for the year 2023. In the second para lordship will find the renewal registration number is hereby valid up to March 2023. His certificate was valid up to March 2023, whereas he submitted his bid on 1/11/2023. This is another bidder who secured who's in the final technical evaluation, who secured higher marks than. By submitting this invalid registration certificate, that way that was evaluated lordship. Complete arbitrariness. Diganta Buragukai, he secured 93 marks, second position. He's already letter of acceptance has been issued in favor of respondent above follow. But I have made a statement. Yes. Yes, fine. Already letter of acceptance has been issued by ignoring this 2%. That is in favor of the respondent number 4. So I have made him part, respondent number 4. Already letter of acceptance, your lordship will find at page. Highest bidder. That is not so far mentioned. And no, or that's on technical evaluation. This is regarding technical evaluation, my lord. These their technical bids were open and evaluated. I'm on that juncture report. It is for for some beautification and development work. Yes, beautification work to the temple site. Yes, L1. I am also L1, Lordship. My bid and respondent of are similar. I'm the lowest one. We quoted the similar. He's higher than me so far. No, Lordship, what happened on the tech? It started at the very beginning, arbitrariness started on the technical ability. Despite submitting the invalid registration certificate, he was scored higher marks. That is so done. 10 or 310 2023. Or 4.3. And Lordship Annexure 11, that letter of acceptance has finished. That is at page 160. No, no. Letter of acceptance is issued only asking him to furnish security.
One hour.
Nothing. Okay. I'll take step. Lordship page 11, Annexure 11, page 161. That may be. Otherwise, they are going to issue the work order. Your lordship. The primary facie I have shown your lordship the arbitrariness during technical evaluation, your lordship. The technical evaluation report I have shown your lordship, I have already pointed out in despite invalid registration certificate that is on technical evaluation, he secured second position. If they are ready to issue that. No, lordship may make some observations of that because that illegality that was. Now I am submitting, I have submitted document your lordship document. I am also satisfied. So see then lordship. Problem. Yes, sir.
My lord, this is an application against an award of the Labour Court, my lord. Uh, this side is not here. It came low. And in the last date, that is on 6th of March, they had filed one affidavit. I'd like to take action on that and file it. Uh, yes, 10 days, my lord. It's affidavit in opposition filed by the respondent number. Uh, 2. So then, can I have a date? After 2 weeks, can you get? 4th of April. Today is 15th, 14th, 5th.
But it's fine, but sir, I filed a additional affidavit every third. That is not tax. This is a order of the Honorable Supreme Court of India
passed on the 25/10 of 2010, directive. Simple. And accordingly, compliance of the order I find a title put in the notice number 1 in Sukia. And that in order, the order of the Supreme Court, it is directed to dispose of it within 1 year. But till today, it has not been disposed of. Again, I find a writ petition in this High Court that the writ was also directed to dispose the fruit within 6 months. But on 2018, from 2018 also after 6 months also it has not disposed. And moreover, post sending, it will be wait. So it's the photo that it's just in addition to the photo by children's protection, somebody died, some children fight for treatment. That is getting not getting delayed, but getting is going on. In the meantime, he has again come to the High Court, filed a petition, which saying anything, many other things, that is within to say, nothing else. He has even made the district judge the party. Once it's time. Parties are specific commitment here that all specific affected civil court, civil court. Who is the player? Play the part. What? But willful violation of the order and there is a yes, yes, that is notice number 1. Notice number. Notice number.
This is order of Supreme Court of for compare this was the president. One year. Civil Court. Yes. 7. Deciding officer of the major district court is a party. Yes, of the request. You can get that. Plus, what happened was that one of the court was second. So the full state court was transmitted to Margarita. But because it was available. Twenty of 11.
Renumbered as PS 9 of 2017. Nine of 17. PS 9. PS 1 of 17. What is happening here?
This state has transferred to
Huh?
Margarita.
It's before learned Munsif Margarita. Who is the petitioner? Plaintiff. Who is the plaintiff? You are the plaintiff. You have asked for judicial inquiry by commissioner. Then how can he complete everything in one year?
But there is a director of this court looking into the nature of this court.
No. So now it's before learned Munsif Margarita, 1 of 2000. Again, gone back to this. So it's pending here. There is some record here. Or what? It is the Honorable District Judge Tinsukia White order dated 5/8/23 transfer the case record to this court. No, this is sorry, this is the civil judge Tinsukia. I don't know. This is Who is this Manashi Mandal? Who is this? Okay, right. On considering the status report on TS 20 of 2011, passed in connection with the present case. Come on. No, don't say that. You have said out here that the instant dispute is creation of the Honorable High Court and Honorable Supreme Court by absurd order. Absurd order.
Yes, my lord, there is a order passed by the High Court, interpreted court, to restore a piece of land which is not in a.
We'll consider your case again. Right. The matter needs further examination. List the matter after 3 weeks.
And in this case, my lord, if drastic steps was taken, and that was served to the respondent number 4. In spite of that, my lord,
Item?
item 7. I have filed the affidavit to that effect also. It was filed on 15/12/76.
What are you challenging here?
While challenging the settlement in favor of the respondent number 4. Because my lord, as per the provision.
Why?
Because
On
by
what
the-
ground?
My lord,
On what ground are you challenging it?
on the document he submitted, the
Ah.
document of the land document and the non-independent certificate, the land is shown actually whatever is more than his position.
More than his position.
So, this-
Land is shown more than his position?
Yes, hello.
How does that have anything to do with you?
No, my lord, because the document as per the NIT, the document.
How does it affect you? If land is shown more than his position?
Because of the wrong document submitted,
Ah.
this NIT was this tender was accepted and customer was in favor of. So
No, but how does it prejudice? Suppose, let me ask you a question.
because if it is not accepted, and this will come to this.
Okay, now, but what is the requirement of submitting land documents? What is the objective?
Objective pilot is NIT is logically will go by the NIT clause and the tender terms and condition pilot.
Yes.
It annexed
Yes.
at page, it is annexed to at page 28A. The first one.
28A.
This is what the application, NIT application form, where it is clause 4,
Yes.
logic 20, but
Yes.
it's land document.
Yes.
So Roman 2 and Roman 4, I am in ballot on that.
Ah.
Land valuation certificate issued from the DC, ADC, SD, SDOS, and SDOCV. And next pilot Roman 4, non-encumbrance certificate issued from the sub-registry office. So these two documents he submitted,
Ah.
where he shown his land most actual point. His possession is 4 bigha, 1 kata, 12,
4 bigha,
4 bigha, my lord.
1 katha.
Then I am just repeating. His actual possession of land is, my lord, it is his shown his land under possession is 5 bigha, 15 kata, 12 satak,
15 katha.
12 satak.
Satak means lechas. Or what?
15 bigha, 5 bigha, 15 kata, 12 satak.
How do you spell sakat?
CHA.
CHA. CHAK.
Yes. And probably it's a letter. It is in
Must be lechas.
letter.
Lecha.
So it is a state satak. But the
Is it lecha?
that is
Cannot be
in
katha.
Bharat mainly, my lord, this
call is Satak.
Okay,
In our
CHAK. Okay, then,
and
and actually he's in possession of 4 bighas,
the actual possession is my lord, 4 bigha,
1 katha,
uh, kind of, uh, he stole out of which my lord here, uh, 1 bigha
1 bigha, 4 bighas.
to, no, one bigha. He
One
stole my
bigha.
lord out of this portion, my lord. He
Ah.
stole 1 bigha, 4 katha, 4 shakat. He already stole
He sold 1 bigha,
1 bigha, 4 katha, 4 shakat.
4 katha.
So land is not actually in his possession, whatever is stolen.
So basically, he has with himself 4 bighas, 11 kathas,
Yes,
and how many kathas? He said? 8.
8 shakat.
So he's got that much, correct? So he still got land.
Yes, madam.
So then,
Stole the more than the whatever is stolen.
huh?
He's showing in the land of
He's showing more than what he actually.
He is saying that this land is actually under his
But how
possession
does that have any relevance?
because the correct document is not there.
No, it's just that he has not made a correction of it. That's all.
But,
Uh,
but the NIT ballot that cannot be subsequently.
What is the objective of the land?
Ob-
Objective of issuing this land?
is ballot to determine the value of the land and the that land should not be encompassed to any other person.
Are you sure?
That was
Are you
not-
sure?
Ballot.
Are you sure that is the reason?
Yes, that is the reason also. So know this kind of land value because the standard value, whatever is by value is there, that should be covered from this land value. So that was the reason. And another
Isn't it for the purpose of covering a person's portrait bid value? Say that. That's what I was asking for actually. And you are skirting. Unless I tell you in black and white, then you were not planning to blurt it out.
well, this property value is concerned, but it is covered. But the document rely showing this land value, that means not defective document is in rely. So on
No,
that,
it's not
the
defective.
standard value, the standard once the company is on the correct document.
When his spotted bid is covered, you have got no. You have
No,
got
but
no.
the document is whatever is issuing from the authority concerned is giving the affidavit also.
It
The
has,
affidavit is not
maybe it has not been corrected. That's all. There's no lie.
Our High Court judgment in the Abdul Majid case. and
Show me the High Court judgment. Show me the High Court judgment.
Another case, I can rely on. This is a recent case, in Bhakti case in our High Court. Then in subsequently, nothing can be rectified. The last final.
Your tender was because you quoted lesser amount.
Hello?
Your tender, your bid. Why was it little less? So it was not accepted. Otherwise, it was a valid bid. Yes, which paragraph?
So the last paragraph, two minor actually.
Last paragraph.
Last paragraph, last but two, last but
Paragraph 2.
where it is saying that
Yes, where? Please read. Where does it say?
one copy that is on to the
Yes, where does it say?
मतलब here said that nothing can be वाला as part of NIT condition everything to be fulfilled. So no can be वाला subsequent मतलब any correction can be done as part of वाला say that the Supreme Court also saying that our court also is nothing to be said today is going to मतलब bring this case. But Abdul is saying that NIT cannot be मतलब subsequently be rectified.
What?
NIT cannot be subsequently rectified.
Who's rectifying? He's not rectifying anything.
So if this is accepted, there will be the amount to rectify that.
Nothing like that. Sorry.
This suitable of the
Just a minute. Let me read the order. thus the bid value offered by the petitioner was lesser than the amount of the land value of its building. This is a different issue. Out here, his land value was less than the amount that he had offered.
That is offered, but if both the tender wala there was same land was offered. So that is the reason that one got down, that was the. But let's say my case is this side.
Just a minute. Yes.
Well, fine. That's what it comes from the of 7. The tenderer must have to submit one non-income certificate regarding this land revision. So my that record, whatever is right, that's the correct. So if it is not correct, some discrepancy, some deficiency are there. So that cannot be accepted as a so this is my thing. So the land is showing 5 bigger 12 kata and stuff. But actual position is not that. It's less than 1 bigger 12 kata. So obviously the document is right. This is not a but otherwise the settlement will be awarded with 31st March. Right. It is also
Yes, yeah, for response number 2. One twelve. Response number 4, you serve it to the wife.
it is in home while I went there, but he is not available so why but home.
I don't know, I think there is a judgment passed by a coordinate bench with regard to serving on the wife. It
Yes.
should be to a male member, something like that, no?
That was there, but
Then?
actually he was kind of avoiding this. So ultimately, the wife has to receive it completely. Somehow that was as the dedicated of job. Yeah.
So did the government know that he had sold one kata of land,
Yes. Government manner,
1 bigha of land?
from the document manner, whatever I like is from the government, but
So the government knew. The government knowingly
no,
still gave.
but probably that was there, but the actual tax was not incurred at the time of the issue because as per his statement, the land is when a tag number, subta number is also same. And because one reason is there, the land, although he sold, that land was not mutated in that particular. That was continuing in his.
Then,
So that was the reason.
then what is wrong?
But he should have given the true facts before the authority concerned that I have told you.
He is not here now to
And to get authority has given evidence of that I am a positive cat.
people. Then how
So
do we
evidence cannot do that effect of.
so then how do we decide this thing? Whether you're correct or the defend or the response number 4 is wrong?
But the RBI just try to update it out of it.
But then it is absent of an issue.
Otherwise, by one fair ballot is that may be disposed of, but the one is fair ballot. No further extension after this. Because the tender has already been sorted for the next session.
If it's already floated, where's the question of extension?
It is already sorted and from the first of April.
Then where's the question of extension? Have you applied? Have you
I have also
participated?
applied and he also applied.
Then you come.
But there is every possibility that without settling this thing that can be extended for another 3 months. Because there is a tender process, some time is taken to finalize the entire thing.
No, we will not go into this. That is not the
That's
issue.
not final, I on the matter. That's only my share.
That is not an issue.
Well, it is. Otherwise, they will go for the perfect. Continuing that, allowing him to. Yes.
But then where is your case?
This is my understanding.
I cannot. It's not. You come here, give me an extra seat or give me an extra uh, laddu or whatever. That cannot be done here. It's not a. It's not you come here and ask.
I
You
think that
beg
there
for
is a-
something.
There is a case because whether basically wrong document, nothing can be finalized.
Right. Heard Miss Pati Mahantala, counsel for the petitioner. Also heard Miss S. Bora on behalf of MD Bora. That is counsel for the transport department. No one appears on behalf of the respondent number 4. Gustav. The affidavit of service filed by the petitioner on 15/12/2023 states that no, yes, states that as the respondent number 4 was not in his house, was not in his residence at the time of service of notice, the notice was served upon the wife of the respondent number 4 on 13th Feb 2023. Now what to do? The coordinate bench has said that service of notice on the para 6 is not service of
I
notice.
surely understand.
Huh?
I am. Person concerned, there is a judgment also, but the other significant can also.
No, I cannot say now
I am not going.
because so we cannot say that he has been served also. Then.
Actually, better of very that. Better in better.
Right, right. The petitioner's case is that pursuant to NIT dated 4/11/2022, issued by the respondent number 3, the bits of the petitioner and the respondent number 4 were found to be technically responsible. Though the bit of the respondent number 4 was higher than that of the petitioner, and the settlement of the Lalchi Mara ferry service had been made with the respondent number 4, comma. The respondent number 4 did not possess the actual area.
Just because mentioned in our affidavit,
Yes,
according to the report submitted by the Deputy Commissioner Pachar, the representative force posited that remains measuring 4 kachas with 17 kachas, which is covers the exported
okay. Yes,
according to the report submitted by the Deputy Commissioner.
yes. So that's
I am not depicting. It's covered.
Covers
When may to cover this date.
what I said. Of the land mentioned in the land document submitted by the respondent number 4 before the tendering authority. Yes, sir. The petitioner counsel submit that the respondent number 4 had submitted land document showing that his land covered an area of 5 bighas, 15 kathas, 12 shakas. What is it? Though in reality it was only 4 bighas, 11 kathas, and 8 kachas. Kachas or lechas, whatever.
Yes, sir.
Lecha. Lecha. In as much as 1 bigha, 4 kathas, and 4 lechas have been sold by this point number 4.
Mass people.
Huh?
Mass people. Long time.
Sold by this point number 4 prior to submitting his tender document in person to the NIT dated 4/11/2020. So, sir, the petitioner's counsel submits that as the respondent number 4 had not submitted correct document before the tendering authority, the writ petition should be dismissed. Okay. He also submits that the term of the period of settlement of the ferry service is till 31/3/2024. Correct? Yes, the page,
Can I do that?
Miss, your name, your name, Miss S. Bora. I've already sent in a meeting. Letter counsel for the transport department. On the other hand, submit that the respondent number 4 had quoted rupees 3,94,565, while the lead petitioner had quoted an amount of rupees 2,55,00. He submits that a complaint had been submitted by the petitioner against the respondent number 4, and the deputy commissioner had submitted a report of the land document of the respondent number 4, which was to the effect that the respondent number 4 had sold an amount that had sold land measuring 1 bighah 4 kathah and 4 chatak THA out of his total land measuring 4 bighas 17, 17 kathas. However, the remaining land covered his quoted bit. That is what is given here. Covered his quoted. Now what is to be done? Let them take a decision. The tendering authority.
There is no decision to that effect.
Huh? As to whether they should cancel.
Why not? I see whether this out today for the. So. Why there is none of it?
To stop this para. On considering the submissions made by the council for the parties and the pleadings in the record, comma. It appears that though the respondent number 4 had sold a part of his land holding, comma, he had not made, he had not corrected his land document. However, as stated by the respondent number 2 in his affidavit in opposition, the land, the remaining area of land in the possession of the respondent number 4 covers the bid amount submitted by the respondent number. Further, keeping in view the fact that the settlement of the ferry service is to expire in and by on 31/3/2024. This court is of the view that but
No, madam, going to be, madam,
that anyway we'll dispose it of. I'll see what basically dismiss and dispose of.
madam, the on this chamber, madam, the justice also.
Huh?
This is madam, because of the lack of time, madam. So the, five days is just, madam, so, but that's not, but the madam, just, madam, but, so, just going inside the all center.
What have I said? And that uh, it would not be in public interest to enter into the merits of the case at this stage. Further, there is nothing to show that. No, we will not say further. Put up accordingly. In view of the real state above, this court is not inclined to exercise its discretion in this stage. So this petition is accordingly dismissed.
The only one of them, but not the, so,
As this court has been informed that a fresh tender has been issued for settlement of the ferry service. It, uh, the the settlement of the ferry service for the next for in terms of the tender notice dated.
David, I don't know, madam, this is, madam, recently, madam.
You said you participated.
Particular, but this knowledge will be got.
Okay.
Madam, thank madam, you already informed.
The settlement of the ferry service should be made within the stipulated time, provided therein in the NIT. However, should be made applicable from the next from the next season.
Yes.
From the next season. That is 1st April 2024. I'll make correction here in there.
Right. This is true.
Huh?
This is true, madam. You can't. Awesome.
But there's no fault on the part of the
But
respondent.
all these, but even then, my lord, if it.
So you should have clarified that, yes, I've
But
got.
that cannot be clarified in subsequent by right. It has to be only one.
No, I mean, it should have been clarified at the initial, while submitting his bid document, he could have said,
I think our high court also, they say once the tender is accepted, but nothing can be done.
no, but out here there's nothing to show that he's been sold well, that they have to go to a civil court to prove your case.
But it is admitted that his whole plan long back, 10 years back, but that was still continuing.
He has not admitted. He's not here.
IPA, my lord, I.
Next.
Awesome.
Hello, my lord, my lord. The record not received.
No, it's not your name. How can I say? Supposing supposing someone comes here, Donald Trump's friend comes here and says that no, you record Donald Trump's name. Can I do that?
As per the office note dated 13/3/24, the service on respondent
Item?
from the
Ah,
as per the office note dated 13/3/24, the notice on respondent number 6 has been served, whereas the respondent number 4 has remained unserved because the addressee has left the RTS. So the vacancy office. Also, the respondent number 4 at that point of time was the Special Director General of Police, cum Director Fire and Emergency Services.
So what is to be done?
So he has now been transferred as Commandant General of Home Guard.
So there'll be a new person.
No, Lordship, we have any personal bias against him. He has been made by party by name. So, Lordship will take steps on the respondent number 4 and he is present. He is presently the Commandant General of Home Guard.
You'll have to make an amendment of the, this prediction. It is not like before, Mr. Council, that notification is there by the High Court. Huh?
No, Lordship, we have made him party by name, but at that point of time, the address is changed.
So it was not served on him.
We took a serve on him because the address was changed.
You changed it, then what is the address now?
So he is presently the Commandant General of Home Guard. The office address will be opposite Lakshmi Mandir, Besola, Siniali, Saurabh Nagar, Besola, Siniali, Goa.
Respondent number?
Respondent number 4, sir.
So you have to make you have to pay for amendment, you make an application.
Actually, it's only the address which is changed. Maybe because respondent number 3 is the special director. That is already a party.
So that has to be-
What will take instructions from my client?
You see, it's not like before, where we used to allow you to do by hand. Now it has to be uploaded, and if we do it by hand, later at the time of order, it will not come out.
What will I take obtain? I will obtain it.
Who's appearing for 6?
I'll file a civic matter for that.
Okay, Mr.
Speak your
Appearing for respondent number 6 is granted.
4 weeks time.
4 weeks time to file affidavit of police.
Say, protect the come from the respondent number 3.
Huh?
Respondent number 3 is being made first.
Okay, Mr. S. S. Roy and Mr. For respondent number 3.
Take paper 1 and 2.
One says, petitioner's counsel submits that he will be filing an application for amendment of the first
I
item.
will obtain instructions from my. What are they?
You can do my anything, just right. Office note dated 13/3/2024. States that no steps for issuance of notice upon the respondent number 4 to justice service has been received by the secretary.
That was also part.
So you do that. Once you give by justice service,
Will take the judgment.
but then the you do that. It's a matter of the 4 weeks.
One, 2, and 5, and 5 there.
Huh?
1, 2, 3, and 5 में पाते हैं.
Yes,
All right.
After the country pass over for timing, architect survey is in the exit post number 1. I think.
Huh?
Fly is the transfer of the better. Better.
Did I make any notes out here?
Last time also the doctor was searching, but.
It is there. No, not this. It is there. Go ahead. There are some notes. Let's see that. What to do?
He's in exit post number 1.
Have you got any other matter? Okay. What to do? This is Mr. RKD Chaudhary not there.
Okay.
Huh?
He said that other number of times. Okay.
Give me the other.
Yeah, physiology. Plus, item 9 and 10, these are interconnected methods. So here is my lord, there is a tea garden, and whose land has been found to be surplus by the revenue authority. And
Huh?
there is a tea garden in the district of Sistagar. Now it is Saraidev. Now, the part of the land of the tea garden, has been found uh, to have been illegally occupied by the tea garden. That is the allegation, of course. Now, an exercise was thought for whereby the names of the tea garden, so far as related to that particular land in question, was struck out from the record of right, revenue record. And against that, being against this first restitution, the item number 9 has been filed. There, the proceedings are complete.
Item 9.
Item 9.
Yes.
But so far as item 10 is concerned, that is again, arising out of that district strip of land. Now, there, the PWD authorities have, invited for a tender for construction of road. Now, that road, if it is constructed, will go in between that district strip of land. In the second petition, no affidavit of the, either from the revenue department, taking Apollo reported, as well as for, the PWD has also been filed. Now, under that circumstances, I am paying for 4 weeks time,
Mr. Counsel, this matter pertains to 2015.
right?
How many times have you asked for 4 weeks? For 9 years?
So, 2015 we are ready, but
Okay.
yes, but so far as the second part,
2020.
2020 method,
So from 2020, how many times have you asked for 4 weeks time?
that's also because
Huh? Every year there are how many 4 weeks? How many? There are 52 weeks in every year. Multiply by 4 is 200 and something week. So and divide that by 4? 25 times. Not 50 times.
I am in the receiving end, I cannot, I cannot open up my abdomen with full factor. So, under that circumstance,
No, you see, but
for
no, isn't it interconnected? The issue is basically the pond, correct?
First, the classification of the tea garden has been changed. That we are challenging the first district, item 9. And item 10, now they are, PWC has used a tender for constructing a road by side of the foundation. As the first district is pending, second district is, so they are interconnected.
so far as the first,
So the question is, you had bought some land
Correct. The tea
and there was a pond inside the land.
inside the tea garden.
Inside the tea garden,
Yes.
there was a pond. Now they are claiming the pond to be there.
Second district, they are claiming.
Who is claiming? Which
They responded. They are invited the tender for constructing a road by the side of the pond.
the PWD is saying
That's
that.
the PWC.
So they are saying that this is their land,
Yes.
government land.
They are trying to, they are changed the classification of the
Huh?
land.
now in the first petition, inside the tea garden, there is a pond.
Yeah.
We say that that pond would not have been the personal property of the tea garden because of the fact that that pond had a historical legacy. And the pond, it was a part of the tea garden, so an exercise was drawn up by the revenue authorities, whereby
That
in terms of a code load. And that might not, everything complied, might not principles of
Where was we an author?
Ah.
In the, that definition, we an author.
Now that classification has been changed. Now, once the classification has been changed with regard to that font, the nature and character of that area has been changed. Now, in accordance with law, once the classification.
No, no, I want to know one thing. What about the area surrounding that pond? Whose thing is that?
Tea garden, you know.
Is the
Yes,
tea
yes,
garden?
tea garden.
So it's like saying, that this, so here, the government has got government land is as an island inside the tea garden. Is it? Is there any?
Yes, now, so far as minor, now what regards the action of the government, there were series of public complaints. Against minor, if the public complaints was focused on the line that pond was legally enclosed by the tea garden. It was a public pond. The tea garden could not have enclosed over that pond and the surrounding area, of course, and it was used by the Assam community for rituals since time immemorial. That was the
But who gave them the land documents?
land documents were at one point of time, of course, the government.
Yeah.
So therefore, on merit, why not all people definitely decide on merit. Now the pleadings are complete. So far as the 2015 matter is concerned, I am seeking an accommodation for pilot with regard to attempt number 10, 2020 matter. So it's sincere apology, but definitely I have to put some side.
And according to you, one cannot be decided without the other.
Yes, yes. Because ultimately, my lord, the status of that bond will have to be decided. So as a last opportunity, my
How much time?
4 weeks time. In between, we will find the affidavit.
For the PWD you'll file or for who?
For
For the state respondent. Revenue.
For the revenue authority.
Yeah, right. What do you have got to say?
They are already protected in the interim.
Okay, right.
We'll find the affidavit.
Mr. Bor Pujari, R. Bor Pujari, Learned Counsel for the Revenue Department,
My lord.
submits that. Now, praise that he may be allowed to file affidavit in a position as a last chance in WPC 1470/2020.
There are
That-
interim orders.
Huh?
There are interim orders.
As the same is not objected to by Mr.
Say that, you know.
A. Das, Learned Counsel for the petitioners. The praise allowed. This is the matter after 4 weeks. Interim order to continue till the next day.
I'm so obliged, my lord. Obliged. Apology is not for inconvenience or sick for hearing. We should have found our affidavit.
Item number?
This state citizen is directed against the illegal and arbitrary.
Huh?
This state citizen is directed against the illegal and arbitrary decision-making process adopted by the appellate authority of APTCL. Even in the absence of any jurisdictional fact connecting the petitioner for any malpractice, the petitioner was held guilty of malpractice. So for proper appreciation, I would like to take your lordship to certain documents. Your lordship may kindly come to annexure 1 minute. Page 60. The type copy you will find at page 67.
Page,
Page 66 is the photocopy and page 67 is the typography of the relevant extent.
Yes.
The Lord may kindly come to general remarks column on observation. The table. Read.
yes,
As per the report dated such and such, an instruction from BGM PhD, the scripting of CTPC along with the meter is done at the NGO 55. Meter data is downloaded for CMRI analysis. Lord, as per this inspection report, my meter was fitted outside the computer.
yeah,
Outside consumer meter
yes.
are fitted outside the boundary wall.
You have shifted it outside the
No,
boundary wall.
PDCL has. This is the inspection report prepared by
Where does it say outside the boundary wall?
the shifting of CCTV with the meter is done at the entry of the premise.
Entry of the premise.
Yes, it is outside the boundary wall and
No. How,
the
entry.
electronic evidence is there that I will place before your lordship. The CD prepared by the
Mr. Council, how can you say when it says when it's in the entry? What do you mean? How can you say that it's outside?
Milord.
Entry can be inside also. Supposing this is a gate. This is a gate post. Say, this is a gate post. Supposing it's fixed to the gate post. Is it outside or inside?
Out. Milord, if because there is a provision below in the supply code as well as the electricity rights of consumer regulation. If the meter is installed outside.
Outside what? Outside what?
Outside the boundary.
Boundary.
Outside the
Outside the boundary.
Yes.
Yes, if it's outside, installed outside the boundary, then what happens?
that case will be there. Responsibility will be on them.
That is a different thing. My question is this. Supposing this is your house. I am the house. Say. This is the boundary pillar where the main gate is. Supposing it is fixed on the boundary pillar, the meter. Is it outside the or inside?
Then it will be inside. Then that will.
So that is why I'm saying.
But my
That is why I'm saying. Let it be very clear. When you say the shifting of CTPT along with the meter is done at the entry of the premises, it doesn't mean outside the premises.
there is a CD prepared by them below in the inspection below. I will place before you.
That you see, whatever you've got some photographs and everything, but please do not try to influence the court by trying to play around with words. It says here at the entry of the premises.
They have written like that, but your lot will find from their own door.
Say that. That's a different thing. That's a different thing. But don't try to make out a case that entry means outside.
Now, my lord, there are three provisions. If the meter is installed outside the premises, in that case, the responsibility will be upon the APDC for the safety of the meter. And in such circumstances, there are two judgments by their own authority, my lord, by the APDCL. One by the ombudsman and the second one by the chief executive engineer of the APDCL. This shows that if the meter is installed outside, then any bill served upon that cannot be installed. I will place those two judgments before your lordship. Regarding the first point, may I place the provision? Your lordship may kindly come to close 4.2.1.2.5 of the supply code. This book. Page number 21.
4.2.1.2.5.
2.5. The consumer shall be responsible for safe custody of the meters set out MCDs CB, etc., except in cases where such meters set out MCDs CB, etc., are installed outside the premises. So if the meter is installed outside, then there is no response. Now, the
So
second,
now with your case, how do you, where is the meter installed outside or inside?
outside meter. This,
So it is
their document will, this electronic evidence. Everything will be clear from their inspection report itself. So this is, they prepared below. Video. In fact, CD is also there under the signature of their officer. CD is,
where-
Lord, I have written what is there in this document. There are 5 videos below, short videos.
So basically your case revolves around the meter being outside the premises.
Not only that, below. Your lords will find from the video, my lord, at least 4 seals were cut by them to reach the circuit. Seals of the meter were cut by them. Even the cabinet box, my lord, if these doors are closed, my lord, if these doors are under lock and key, somebody says that some tampering is done. It can't be understood unless and until it is established that the locks of the doors were broken. That your lords will find.
Yes, this is
First seal that was cut by them is the cabinet box. Inside is the meter was placed.
no, we do not know if this is outside the residence or within the
The
compound.
boundary wall is there. It is immediately on the starting of the video, you also will find that boundary wall. This is in the open space. This is not,
It must be within the compound.
because boundary wall is there.
So,
I am inside the boundary wall.
so this is also inside the compound.
The second point, Milord, you also will find that 4 seals were cut by. Milord, there are judgments, Milord. I will.
Issue is something
There are-
else, your lordship. Issue is regarding tampering of a meter. It is not whether it is outside, inside. There were foreign circuits found installed inside the meter. That is the issue, your lordship, because of which assessment procedures were conducted again.
Yes, then what is,
Now, Milord,
how long will you take? I want to be very clear on that. How long will you take?
okay.
Finish it. You finish it for half an hour, there's nothing here.
Now, Milord. Your lordship may kindly come to annexure 3. Page 70. The type copy your lordship will find at page 71.
Page 17.
Page 70 is your photocopy and the 71 is the type copy of the relevant extent.
This page 71 says what?
Look, this is the inspection dated 34/2030, 2014. In the top your lordship will find.
Yes.
Now your lordship may kindly come to serial number 4 in the table. It will show the present status of the meter metering equipment. And the type we can,
What page? Yes, I have. What is page 71? Now, what do you have to show?
serial number 4.
Yes,
Present status of the meter metering equipment. The written portion your lordship will find in the page 17.
17.
70. Previous thing. The details is given me.
So what?
So the Lord, every consumer is billed on the basis of these parameters.
So,
If there is any tampering or if there is anything done to the meter, then this will be reflected through here. Whether there is any tampering, whether there is a disturbance, whether
that's the way I going to go there. The report.
yes,
Not a court of, we are not an appellate authority going to scrutinize.
Lord, power of
Yes, everything.
judicial review, Lord, is available. So far, the
Unfortunately, not as much as you do, but I try to,
Lord,
try to.
Lord, what I am trying to emphasize, one cannot reach the meter unless and until these seals are broken. That
Right.
has to be established by them that the seals were found broken. Your lordship may kindly see this overall MF just below serial number 4, there is a serial number 5 below. Your lordship may kindly see right hand column, right hand side column.
What do you mean, please?
Right hand side column of serial number 5 below.
Yeah.
Your lord, these seals were put during this inspection. These seals were new seals were placed by them during inspection. Because there is a provision, my lord, under Central Electricity Authority installation and operation of meters regulation.
Let the council, no, that is not going to go. These are put by them, not put by them. Are these in your bidding?
Yes, my lord, these are,
Show me, where have you said that these are in your bidding? Let us go straight away to this.
yes, my lord.
Where?
Your lordship may kindly come to para 8, page 13 of the DFPD.
Para 8, page 30, this.
Sub-para. It
Yes.
was observed at serial number G of the
Para
aforesaid
8, page 30, okay.
page 13.
Yes.
It was observed at serial number G of the aforesaid inspection report that the seal surface with the meter terminal cover only was found broken and there was no observation regarding breakage of seal with the meter cover or the cabinet work inside which the meter was placed. Therefore, the observation made at serial number G runs contrary to what is observed in general remarks of the inspection report. Moreover, the seal of the meter cabinet inside with the meter having been found intact, there could not have been any reason to find any fault with the consumer petitioner regarding the breakage of the seal of the meter terminal cover and or the meter cover. Because I will place a judgment of the Allahabad High Court in this regard. And there are, my lord, other paragraphs. Para 39, page 35. And then the
Yes. What else?
these the statements you also will find at other paragraphs also. Sir. You wrote-
Yeah, just a minute. I think we're going to take the forever. Just tell me in short what is the
I
case.
have just prepared a short list of this.
Yes, yes. That'll clarify it. And then we're getting stopped in these minor things. Yes.
What has happened was on 26/9/2014,
Yes.
an inspection was carried out in the premises of the petitioner.
Yes. Yes.
That inspection report, your lordship will find at page number 72.
Yes.
In that inspection, what we found was there were external circuits installed inside the meter.
Okay.
Breaking of the seal is not important. There were circuits found installed inside the meter.
What? The external circuit.
Yes, it report says
Page 72.
page 73. After, if I may just read the general remarks, your
Yes.
lordship,
Yes.
general remarks. Transmission and commissioning team visited the metering installation as per the area manager's letter number so and so. RTC error and white paper seal on the meter cover is found to be torn out. A new meter cover bearing seal number so and so is connected. The LNT meter, which is the company which makes it, is opened in presence of the consumer representative who was present there. After opening of the meter cover, foreign material stroke circuits are found fitted inside the meter wrapped with PVC cable. Photographs recorded. The team decided it is a case of malpractice. Accordingly, the line is disconnected by observing formalities. AG and Duliajan division shall lodge FIR as per rules. The new secure meter bearing serial number so and so is disconnected, and meter with details as mentioned above. The tempered meter is taken with paper sealing number so and so. This is the allegation that his meter, there were foreign circuits inside it. Now, as per section 126 of the Electricity Act, your lordship, when a person indulges in theft, there are two sections basically under the Electricity Act, your lordship. Section 135 and 126. So when a person, this is a clear act of theft of electricity, your lordship. So when a person indulges in theft of electricity under 135, for assessing the electricity charges, the procedure under section 126 of the Electricity Act has to be adopted. Yes. So under section 126, your lordship, assessment, your lordship. So after the inspection, the assessing officer has to do a provisional assessment of the charges paid, your lordship, which was done in this case.
This is good. Electricity Act,
Electricity Act, Electricity Act.
this is electricity supply.
Section 126 of the Electricity Act. So provisional, first the provisional assessment has to be done. Then against the provisional assessment, the person, the consumer has the right to file an objection. After hearing the objection, a final assessment is done. And if he still agrees with the final assessment, then he can deposit 50% of the assessed amount and file an appeal before the appellate authority treated under DR. So in this case, your lordship, after the assessment was done, the provisional assessment bill, your lordship will find at page number 76. Then against that provisional assessment, he submitted objections, and the final assessment, your lordship will find at page number 81, which was done on 30 September 2014. When we take your lordship to the final assessment at page number 81.
What,
This
what
here,
made the assessing office, there is nothing being.
this hearing is with respect of provisional assessment bill in favor of so and so, held on 13/9/2014, made by the assessing officer to come to the conclusion that is a case of interference with energy meter. Hence, the penalty imposed that provisional assessment bill already served as per Electricity Act Depository is final. Against this, your lordship, they preferred an appeal before the appellate authority. Now, before the appellate authority, there were extensive proceedings. The appellate authority, in fact, directed APTCL to call for a report from the meter manufacturer. That report, your lordship, will find that at page number 88, your lordship.
Yes.
This is addressed by the officer of APTCL to the appellate authority of 9/7/2015. Now,
By who? By who?
by the officer of APTCL, because this report was called by the appellate authority. It was addressed to the appellate authority by the AGM, Transmission and Commissioning Division. Now, lordship, let me take your lordship to the relevant portion at page number 89 here. The paragraph starting at it is pertinent to mention. First, second, third paragraph. It is pertinent to mention that in response to this official request by the email dated 16/10, this should have been 14 years old, this is a typographical letter. 16/10/14 regarding foreign material stroke circuits which were found connected inside the meter serial number so and so, LNT, replied by their email as below. We hereby like to confirm that the component stroke circuits highlighted in the attached photographs are external materials. These component stroke circuits are not used by us in the manufacturing of the concerned meter. Now, they were present. After hearing both the sides, your lordship, an order was passed by the appellate authority. Detailed hearing, that order, your lordship, will find at page number 130. This is the order of the appellate authority. the 127. Can we read out the order? Your Lord? The case was heard for 3 days due to various reasons. All the parties were present. During the first hearing, AGM TNC division explained the whole case. The case in brief is that the AGM TNC division Dibrugarh, along with IRCA Dibrugarh and APPCL engineers from so and so, inspected the metering system inside the premises of Messrs so and so, having a connected load of so and so on 26/9/2014. During the inspection, they found some abnormalities in the meter and they opened the meter in front of the representatives of Messrs so and so. Some foreign circuits and elements were found inside the meter. Everything was videographed. Finding this malpractice, the final assessment bill of rupees so and so was served on 13/9/2014. Afterwards, the correct bill of rupees so and so as final assessment was served. But the party has already paid 50% of rupees so and so. This was accepted by the appellate authority. On the first day, the lawyer of the appellant did not receive the reply copy of the response number 2, as appellant did not supply the appeal copy, thinking appellate authority. With some problem with language. So the appellant was asked to serve appeal copy to the respondent so that he can give reply in written. On second day, both the respondents asked appellate authority to allow more time as they had submitted all documents to their lawyers so that respondents can give reply and arguments to appellant's written arguments and submit. On that day, appellant's lawyer forwarded his written arguments against the assessment order of AGM IRC. On third and final hearing day, lawyers engaged by respondents forwarded their arguments against the appellant's lawyer, written reply and submission. After hearing from both the parties and also going through all the documents and photographs submitted by the respondent, appellate authority found that the appellant, Messrs. Gangotri Tea and Industries Private Limited, was indulged in malpractice by using extra circuits in the meter. This was also confirmed by the manufacturer of the meter. However, IRCA Dibrugarh must correct the penalty bill. As per Transmission and Commissioning Division, inspected the meter on 34/2014, the previous inspection, and found everything okay. So the penalty imposed will be from 34/2014 to 26/9/2014. That is the date of detection only, and not for the whole 12 months. The new penalty bill becomes less than 50% of the amount already paid. It should be adjusted in future energy bills of the applicant. So this is the order he is challenging before your lord. Now, his grievance is that he is saying he wants to reopen the.
Order doesn't-
This is the order, your lord.
there is a dispute.
But the lord, who is an appellate authority, perhaps official, but he is saying that he has gone through all the materials and he has applied it. That part is there here.
There's no reasoning.
No.
Not true, about
Yes, that language is perhaps it's not been properly drafted.
the appellate authority, the first authority itself,
Yes,
four line order,
the first authority, if I may just take your lordship to the,
four line order.
yes, the problem is that these are all engineers, your lordship. They would perhaps,
But they should write down, they know everything in their head, what is in their head, they're going to write down.
lordship, but since the appellate authority has applied, it's fine to those things, but those,
Apply to find how, we don't know what is applied, they only talk about.
Yes.
It's like saying, he has submitted a affidavit, he submitted affidavit to police, he submitted affidavit in reply, and since because of the additional affidavit and the extra double affidavit or
Then-
whatever.
may I make a submission, your lordship? Then since lordship, the materials are already there before the appellate authority. Lordship will remand the matter back to the appellate authority, let him pass a reasoned order with all the materials on record.
Let it pass the basic order.
A reasoned order, I have no difficulty. Let him pass a reasoned order, no, nothing fresh should be filed on the materials already before him, let him file a, yes, your lordship, I have no difficulty.
There is a guideline also. No foreign circuit can be inserted.
I'm not on that. More. I'm not on that.
No, yes, your lordship is correct. These
Because
orders
I
are not speaking orders. There is no reasoning, no finding. None of the submissions made by the petitioner were taken. So
Forget the appellate authority. The first authority said there's nothing.
nothing.
So let the appellate authority reconsider, because the first authority, those are in fact technical proceedings. Since the appellate, before the appellate authority, even lawyers can appear. So let the appellate authority rehear them on the basis of materials and pass a recent order. Because perhaps that will put an end to their controversy.
Otherwise, because
And-
we have got nothing to decide. We do not know what was.
What was in his
going
mind?
What is the reasoning, nothing.
The expressions are a little lacking here, but
Very
I
much.
think very much.
If your lordship is demanding, in this case, your lordship may kindly permit me. Give a questionnaire, as per that one, he will record his finding. I will submit my parawise comment. Low points and issues.
No, we will allow you to be heard.
Yes, very
To
good.
be heard.
On the message of
And
the
he will
material
record
already
his
present.
picking order on the grounds taken by him. He will pass
The council better way to put better on how they, if only thing they're going to say, please give reasons and fine.
Yeah, right. Yes.
Very.
On the issues that may be there.
That will put
All the issues are already here.
Yes.
to the issues that are already there.
Already there.
Issues are already
Yes.
there.
Those
Because
are.
the appeal is not
No,
a,
no new issues.
yes,
Yes.
very.
Okay.
Heard with the SK Kejriwal, Learned Council Body, petitioner. Also heard with the KP Pathak, Learned Council for the APJ. There is a page that is very
Order is at page number 113.
In Section 25.
This matter 2015 matter.
Yes.
To send it back at this stage. Is also a problem.
But since it's a very, otherwise.
There is a technical matter, we will not
Very
do
technical.
anything.
It comes in. Our friend is an expert here, but I find it very difficult.
So, but sending it back after 9 years, I don't think it's proper.
If both the parties perhaps perhaps if my learned friend agrees, that he sent back with the consent of the party.
After so many years, will it be proper? I don't think so.
In fact, 45, 46 lakhs is paying with them. I am claiming refund.
Maybe, yeah, maybe 46 then you might have enjoyed 46 crores worth of electricity also. How do we know?
Full amount has been paid.
Huh?
As per their assessment, bill, full amount has been paid. So I am claiming refund. Bill.
Full amount of the amount they got,
So there is one
the
more,
amount that got away might be
there is
different.
one more. On the same set of ground, they also file a NFI. In that case, I am acquitted. And in view of their
Like also, you know, the criminal law, the burden of proof is very high. It's a different issue.
civil liability,
Well, in a proceeding of this nature, it is much easier to find someone guilty than in a criminal case. In a criminal case, the burden of proof is too high.
so there is a civil liability. There is a special provision under section 154 subsection 6. The special court is empowered to determine civil liability.
No, that has been clarified by the.
And your lordship may kindly see
There is a
that there is a judgment of the West Bengal in Orient matter. And thereafter, Calcutta High Court.
No, basically, I think can be decided. Basically, the issue is they have said that indulge by using extra circuits in the media.
Yes. That is,
That's the issue. No point sending it back. And after 9 years, I don't think it would be proper to send it.
I will place one judgment. Calcutta. So that is a judgment in respect of 15 meter limited road. This is the meter manufactured by 60 meter. Here this is the LNT meter. The working is same. Both the meters I have the manual meter. You know,
You see, just look at this Calcutta High Court judgment. Also. No, Allahabad High Court judgment.
yes. Allahabad.
Allahabad High Court judgment. Also.
I have highlighted the relevant portion.
So they are also quite elaborate. And you are the main persons out here who are supposed to make it elaborate.
Yes,
Circuit meter. What is that foreign circuit? We do not know. What is the name of that circuit? What is it? Made by who?
In this case, below it was held, since the steel affecting the meter cabinet itself is found correct, there cannot be any question for the
But those issues have not been taken up by the appellate authority.
that has not been, I have taken my load, but the appellate authority has not been rendered any finding there.
No, no. Where is your pleading before the appellate authority?
Yes, those pleadings were there.
Where?
Your load will find.
No, not in this petition.
No, your load is there. Your document is there.
I guess so it's somewhat of a lazy order, you know. In the representative taking the easy way out.
Very easy.
He's taking the easy way out and just without actually putting it down on paper, what is in his mind.
Just nothing. It's just a one line order actually at the end of the day.
After narrating the fact,
Yes. Not even the fact. They're not saying anything. Look, you see the first from the start, case was heard for 3 days. All the parties present. Case in brief, case in brief. Then appellant was allowed to serve appeal copy. Then allow more time to submit the document. Forwarded written statement. Final hearing day. Forwarded the arguments. Went through the documents and photographs.
that is
That's all. Found that they've been indulged in malpractice. So nothing here.
we make inferences from the records that this is probably what must have been going on in his mind, but
Where is your pleading?
Your load may kindly keep the chance, but I will place. Look, there is a statement in the petition that since those grounds taken before the appellate authority are also the ground, so in order to avoid multiplicity, I have put it. This there is a statement.
I don't know.
Yes, paragraph 20. Page 22, the petition. Paragraph 20,
Page 22.
page 20. Last 7th line, bottom.
Yes.
The petitioner states that as the documents annexed with the memo of appeal as well as the grounds taken in the memo of appeal are also made part and parcel of this petition, the same are not annexed with this in order to avoid multiplicity.
Okay, so do you then okay? I don't know, though I don't want to send it back after 9 years.
no way out.
But then there's nothing here.
It passes a reasoned order, Your Lordship. Perhaps my learned friend, we,
If you both agree, we'll send it back.
I have no difficulty because otherwise it's very difficult.
Because then that for me, there's nothing to look into whether their reasoning is correct or what is the issue that they.
You look, you demand it with a direction to dispose of system within a time bound period by passing a sticking in region total.
Yes. But we can make it a time bomb.
Correct. Third, the respectively one, doesn't talk about the petition, with the AP Patak, doesn't talk about the AP. This thing is order dated 16/5/2015, huh? Para 1, Para 2. Para 2, huh? Next para. At the outset, next para, huh? At the outset, the parties have taken this court to the final order dated 30/09/2014, issued by the area manager, Dibrugarh, brackets IRPA, APDCL, and the order dated 7/8/2015 passed by the appellate authority for the AP for the Assam Power Distribution Company Limited.
Sorry, sir. The date of the order is 14/10. When that is
Which
the
one? Which one?
date of the order under order in June.
No, 7/8.
That
No,
is the date of
below,
the
date of order below.
date of the order is below.
Okay, 14/10/2000. Order dated 14/10/2000. Yeah, passed by the appellate authority. In appeal number 24 of 2015. Next up. They submit that. In view of the cryptic manner in which the above two orders have been issued, without giving any reasons and findings for coming to their final decision, the same may be sent back to the appellate authority to consider the case afresh, to consider the appeal afresh, and fulfill the appeal, to take a decision afresh, within a specified time. Next up, the cause for the party. No, how the cause party submit that. The appellate authority should be directed to give proper reasons and findings for coming to their decision while disposing of the appeal by the appellate authority. Next up, I have read the cause for the party. The final order dated 30/09/2014 passed by the area manager, Dibrugarh, bracket IRPA, APTCL. And the order dated 14/10/2015 passed by the appellate authority in appeal number 24/2015 are reproduced herein below as follows. One is at page 81, one is at page 113. 113 to 114. Okay. Next. A perusal of the above orders show that the final decision shows that the appellate authority has come to a finding that the appellate has indulged in malpractice by using extra sensitivity. However, the process of reasoning for coming to such a finding has not been mentioned in the impugned order. This court is of the view that for this court to appreciate the submissions of the counsel for the party, it is necessary that the appellate authority decides the matter by giving proper reasons and findings for it to come to a according. However, the same is woefully absent in the impugned orders mentioned above. According with the, as per the consent of the parties, this case is remanded back to the appellate authority to decide to take a decision on the appeal number 24 2015 on the basis of materials already there in the pleading. There's a material already there. Before the appellate authority. The decision, the first decision to be taken by the appellate authority should be by way of a speaking order. And after giving an opportunity of hearing to the parties concerned. The entire exercise should be concluded, no, should be done at the earliest. And preferably within period of 2 hours.
In fact, there is a provision for 3 months for disposal of the appeal.
Within a period of 3 months.
It's not
Where is that? Where is that?
127.
Huh?
127.
It says how much?
Says the appeal has to be preferred within 30 days.
747 below new provisions, the subsequent development is equal.
Huh?
Clause 7.4.7.
That's
C.
that
of
might
the
cause a
supply
problem.
code.
That might cause a problem here also because it's a new supply code. Perhaps because the proceedings are under the old code.
No, no, no,
But let me just say 3 months and okay, perhaps.
Within a period of, it takes some time, you know.
Yes.
Within a period of 4 months from the date of receipt of a certified copy of the form. Consequently, the impugned order dated 14th April 2015 passed by the appellate
As
authority.
well as the bill, the consequent bill is.
No.
Let the bill-
No, the bill, so let it be subject to the,
Yes, yes. Take your note, yes.
consequently, the order passed by the appellate authority of 14/10/2015 is set aside. The bills passed by the EPDCL authority,
Shall be subject.
Consequent to
consequent to the order dated 14/10/2015 passed by the appellate authority shall be subject to the final decision to be taken by the appellate. If there is petitions accordingly, disposed of. I think that's the shortcut we are taking. Everyone took shortcut. But then how, otherwise, how are we going to decide
But what has happened?
whether their decision is correct or not? Isn't it? Otherwise,
So in Crunchy Associates, honorable tax court has held that even the quasi judicial was seeking to
Give reason.
give reasons. Then paragraph 47, there
No,
are,
no, there are enough judgments.
yes,
That is the problem, because now to take a decision on their order, whether it is correct or not, there's nothing to show that. Right. Okay, I can quote those judgments if you want. After the first one.
Your Lordship may kindly refer to these judgments that will be taken into consideration while deciding the 2012 Allahabad case 45.
No, no, I don't want Allahabad. I'll put some Supreme Court judgment. Get things.
Okay.
Just write somewhere. Yes. In the case of the Supreme Court has held that every authority, including a quasi-judicial authority, has to issue reason. What is 730? Right, no one appears for the parties of law. Ah. This is the matter, and the interest of justice, this is the matter again after 4 weeks.
And in the morning, I had a in the morning, my lord, I evidence to my regarding matter. Some accommodation.
No, no, you tell me. Tell me what is the case? No, no,
Time, my lord.
no. You have asked for time and again,
my God.
all these orders passed earlier.
Not so much. Earlier, no time was taken, my lord. So,
Are you sure? Are you sure?
last occasion, my lord, the matter was put for hearing. Earlier, it was came for admission, my lord. And regarding the,
You tell me what is the case?
well, the case was, my lord, for rejection of the settlement, my lord.
Huh?
Settlement, my lord. Provisional
Settlement, date of the NIT is dated
provisional settlement, my lord, page number 17, my lord.
17 years. Mining flat.
Mining. 10
Yes.
10 hall, my lord.
Yes.
That as per, my lord, this tension, my lord, subsequent requirement, my lord, regarding the uploading of the documents and all mining.
Mr. Council, that tender notice is at page 10.
Yes.
Tender notice is dated 8/2/2017. And this tender notice is for settlement for 5 years.
Yes.
That is valid for 5 years.
Yes.
So what remains?
It is right, my lord. But, my lord, the regarding the pendency of this expedition, my lord, before, my lord, this,
So have the tender been settled with you?
yes, my lord.
It has been settled with you. Show me.
Initial, my lord, page number,
Yes.
my lord, 15.
Page number
Then
15.
it is the selection, my provisional selection, my lord.
Provisional, page 15, provisional. Okay,
Provisional.
then
Yes, sir. Yes,
Pro-
my lord. After provisional selection, my lord, I have deposited the
provisionally selected. Selected. By letter dated 7/9/17. Yes. Now,
So as per
then what happened?
as per positional selection, there was some, my lord, procedure for maintaining.
Yes, then
Accordingly, my lord, I have submitted the mining plan, my lord, and, my lord, geological report, and also, my lord, the, forest village, my lord, NOC. NOC regarding the, my lord, forest villages, forest area, so the reserve forest area, my lord.
and then
Then, my lord, the, regarding, my lord, environmental impact assessment was called, and that was pending, my lord. That was pending. In the meantime, my lord, the impugned rejection, page number 55.
page 55.
Page 55, my lord. That with reference to the above, I would like to inform you that the selected user agency and proposal for mining contract area in the reserve forest do not fulfill the condition laid down by the government in India by the mentioned letter, for which the same may be treated as consent. But no letter was mentioned. It was not mentioned. Under which letter and which
So whatever it is, mining area, contract area, cancelled by letter dated.
27/4/80,
Where do you get this date?
my lord, is the
27/4/18.
page number 50.
27/4/18. Then
My lord, since no letter was mentioned, my lord, under part condition not fulfilled, my lord, in this matter, my lord. So representation was filed, and thereafter, my lord,
representation, where the representation?
my lord, page number 58, my lord.
Page 58.
Yes.
Page 58. Yes, page 58, yes.
Yes. Then, my lord, the
Representation dated. Dated 36/18. I received a letter of cancellation of the settlement of the Mahal, which was allotted to me. Yes, 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 yes. Yes, yes, yes. So this is your, so you have admitted here in page 58
Yes.
that the settlement of the Mahal has been cancelled
Yes.
in 2018.
Yes.
Then what happened?
so, my lord, and
So no decision has been taken on this.
yes, my lord. Not taken in this, and my lord, the affidavit, my lord, in the affidavit, the one letter is submitted, my lord,
Affidavit
of the respondent, my lord, forest department.
1 to 6.
Yes. Yes, my lord. Page number 104, one letter of the Ministry of Environment and Forest Climate Change 104. In the affidavit, this letter was referred, my lord. That as per this letter,
What is this letter? What I please read it. I do not know.
yes, my lord, this letter pertains to my lord stone quarry. The petitioner's, my lord, settlement was Sand Mahal. And in
This
reference
letter is dated by whom? Issued by whom? Letter dated?
issued by the, my lord, conservator of forest, my lord,
Page 105.
government of India.
24/1. Is it this 24/1?
Yes, my lord, yes,
24/1 2018.
yes, page 104.
105.
Yes, 104 it starts with.
No, in mine it starts at 105.
Yes, my lord. This
This letter, my lord, pertains to stone quarry, my lord. Stone quarry, but this letter is referred in the affidavit, my lord.
Mr. Counsel, whatever it be the case.
Yes.
Your settlement was cancelled in 2018.
18,
Settlement was for 5 years.
Yes.
It expired last year.
yes, sir.
Gone.
My lord, on this,
And you have, and in fact, it has not been settled. You are only given provisional settlement. No
Yes.
right.
elector,
It is only selected.
elector,
Only selected.
elector.
You have not been given any work order. It has not been finally settled with.
No, my lord. My lord, one thing I refer my page number, my lord, 106.
106, yes.
Yes. My lord, this is this letter, clause 3, my lord. Clause 3 of this 24/1/18 letter.
Yes.
My lord, the state government shall clarify the reasons for grant of mining for 5 years, whereas 7 years is minimum duration, as mentioned in Assam Minor Mineral Concession Rules, 2013.
Ah.
So this clause is also there, my lord, in this letter, on the basis of which it is cancelled. So, my lord, for this, my lord, I have, my lord, paid for it to see the accommodation, my lord, regarding this, my lord, term of the 5 years term, my lord, whether, my lord, I will satisfy your lordship, my lord.
That is not your prayer here. That is not your prayer.
My lord,
Let us see your prayer.
my lord, during pendency of the writ petition, my lord, since the term is, my lord, over, and this is not the case of the respondent also, my lord, in the affidavit that the term is cancelled. So, my lord, on this point, legal law point, my lord, I
No. You have to set aside the order dated 27/4/18.
yes, my lord. The cancellation order was, my lord, for set aside, the prayer was, but my lord, since the pendency of the writ petition, my lord, the term is over, and since in the letter dated 24/1/8, there is mention of 7 years term, my lord. So, my lord, for which I have,
Mr. Counsel, you see, you have never challenged the terms and conditions of the NIT. The terms and the conditions of the NIT have clearly stated 5 years.
Yes.
That is a different issue.
Yes.
You have not challenged that.
no, my lord, this was the cancellation, my lord. So, my
Huh?
humble prayer, my lord, yes, my lord,
Their humble prayer is denied.
my lord, to the next hearing, they may be fixed, my lord.
Huh?
On the next hearing, they may
Heard Mr. M.J. Kadir. Yes, anything before his disposal.
Since his period is already over and his period is completed.
Correct. He's not paid a prayer for that. He's not paid.
Lordship, even Supreme Court held that you have no right in mining your law. There's no right in mining. 21 judgment, there's no right in mining. And his
Give me the judgment. I do not know. You're not, you don't want to pursue the case. You don't want to close the case. And your period has expired also.
My lord, for producing the record, my lord, several lordship signing the record, my several dates are taken for producing the record, my lord. So, my delay is on the part of the, my lord, respondents, my lord. It is on the record, your lordship may kindly see the record.
also order call for what are the comparative statement law. But since the period is already over,
For
there's no right in mining.
producing
And
the
there-
record,
and
my lord,
this-
several dates taken, my lord.
This,
It records, yes, but then the problem is during that time.
Yes.
Now the period expired.
Yes, my lord.
5 years has expired.
Yes,
What remains?
That is, my lord, during the tendency of the writ petition, my
So
lord.
what to do?
Yes, my lord. So,
What to do?
for which, my
You blame the court now. You file a case against the court.
no, my lord,
You're taking too long. The period expired.
for which, my lord, one date may be,
Yes,
my lord,
heard Mr. M.J. Khan, for the president.
on the next hearing,
Also heard Mr. R.R. Gogoi. There is also for the correspondent numbers
1, 3, 4, 5, and 6.
1, 3, 4, 5, and 6.
my lord,
एक है यार,
my lord.
there is CET appears for the fund of. The
My lord, on Tuesday, my lord, I will not keep my thoughts regarding this, my lord, the issue, my lord, there is during the contents of the distribution, as per the task.
please do not disturb me anymore. Please. Petition. Has been for setting aside and watching the impugn letter dated 27/4/2018 issued by the Divisional Forest Officer, Kamrup West Division, Sabha, Bamuni Gaon, by which the proposal for settling the mining contract of Besimari Mulki to San Mahal has been cancelled. The further prayer that the petitioner should be settled with the further prayer is that the mining contract should be settled with the petitioner in terms of the in pursuant to the tender notice dated 8/2/2007. Next one. The the petitioner's case is the brief fact of the case is that pursuant to a tender notice for sale of minor minerals dated 8/2/2017 for a period of 5 years. In respect of Bessie Marie Tulsi to San Mahal. The DFO Kamrup West Division, Bamuni Gaon, issued a letter dated 17/9/2017 to the petition stating that he had been provisionally selected as user agency for use of forest land for non-forestry purposes against that's the amount. However, by the issued letter dated 27/4/2018, issued by the DFO Kamrup West Division, Bamuni Gaon, the provisional selection of the petitioner was cancelled. The petitioner thereafter submitted a representation. Thereafter submitted a representation dated 36/2018 to the respondent number 6. No, that DFO is 6. For number 6, stating that he had received the letter of cancellation of the settlement of the Mahal, which had been allotted to him in the month of June from the respondent number 5. He accordingly requested the respondent number 6 to settle the Mahal with the petition. However, the representation dated 36/2018 has not been decided by the respondent authorities till date. What were you doing 6 years?
I have come to the
Unfortunately, our fault also, but then what to do? 25 years have vanished, have gone. 2017 NIT.
let money.
Uh,
Let money over to
why don't you give back the earnest money?
Ready to give. In fact, we have informed him to take that, arrangement to go to the. Already informed him now.
Now, nothing survived. 5 years have gone. 5 years have gone long time back. 2018 cancelled. So, with that. The petitioner also submit that the earnest money of the petitioner is still lying with the respondent. And why did you select him? By the
First of all, the tender, which specifically states subject to clearance of the forest. Land. It's finding it a non-forest activity. You have to get the clearance from the central government. There was no clearing, there is no,
clearance being given.
yeah, because
Nothing on record, when the central government rejected it. It's nothing on record.
the tender itself says that.
My lord. Yeah,
Then
the
it
central government did not, my lord. Otherwise, my lord,
In fact, that mahal that contains 0.95 hectare. Supreme Court judgment says mahal of more than 5 hectare only has a food visit.
my lord, the Supreme Court judgment, my lord, they have enacted, my lord, page 10.
No, I'm not on that, Mr. Council. 5 years have gone. That's more. I'm not on the other.
Yes, that is the issue, my lord.
That 5 years have gone. That become instructors. Their teachers become instructors.
I think that they have to be not. They have to vote, my lord.
So you can go to DB and ask DB. I'm discussing a case not on any other ground, not on merit, only on instruction, on the 5 year period. I mean, if you are agreed, you can go to the DB. Unfortunately, happened what to do with the pendency of so many cases. Unfortunately, your case has gone. So where are you're still lying with these? Sufficient. The sufficient, no 5 years have been done. In terms of the tender notice dated 8/2/2017, the conservator of forest bracket C northeast northeastern regional office, Ministry of Environment, Forest and Climate Change, Government of India, has written a letter dated 24/1/2018 to the Secretary to the Government of Assam, Environment and Forest Department, District One. Stating that the state government has to furnish the following information in case of any fresh proposal under forest bracket Conservation Control Act of 1980 was known for it. Which is as follows. Page 105 from here, one, two, all this stuff, that is it. Sit it. Sit it. 1980. The prediction of the surface that the conservator of forestry has asked the state government to clarify the reasons for grant of mining for 5 years, whereas 7 years is the minimum duration as mentioned in the mineral section 2030. So, accordingly, submit that it is not, that accordingly submit that 2 more years. So, that the petitioner can be granted uh, settlement of the permit for at least 1 year. Okay. That's what the thing with. Okay. As a is granted settlement of the permit beyond 5 years. Beyond 5 years, this is. With the RR proposed to the all the council for the policy department. On the other hand, submit that the area of the Besi Mari Kulfi to San Mahal is how many?
It's 0.95 hectare. Page 17, lecture 4.
0.95.
Yes, 0.9.
So this is minimum, it should be 5 hectares.
Yes, minimum 5 hectare.
Is 0.95 hectares. 0.95 hectares. While the and as such, the and as such if the area of the lease, and as such, if the lease area needs to be given in terms of the letter dated 24/1/2018 issued by the conservator of forest package C. Dated 24/1/2018. The Messi Mari Gulfi to San Mahal cannot be settled with the petitioner in any setup. Further, further, the letter dated 24/1/2018 issued by the conservator of forest package C pertains to stone quarry and does not pertain in San Mahal. Correct?
Yes.
Yes, what do you think?
Yes, madam. Regarding madam this sectoral area, my lord, their document, my lord, the Supreme Court, Honorable Supreme Court judgment, my lord, page number 102, Supreme Court paragraph 9 mentioned, my lord, that irrespective of the side, my lord, that can be considered.
And Mr. R.R. Provide for the submit the censor notice has been issued for settlement of the San Mahal for only 5 years. And as such, and as more than 5 years, and as more than 7 years have elapsed from the date of issuance of the NIT dated 8/2/2017. The this petition has become impossible. I have heard the rest of the without going into the merits of the case. Come on. before time. The tender notice dated 8/2/2017 had been issued for settlement of the San Mahal for a period of 5 years only. No challenge has been made by the petition to the said clause, to the said issue, to the said period of settlement of the Mahal for 5 years. Now, as more than 5 years, as more than 7 years have elapsed from the date of issuance of the tender notice, and more than and as nearly 6 years have elapsed from the date of cancellation of the provisional selection of the petitioner for settlement of the Mahal, San Mahal, this court is of the view that the late petition has become invalid. Accordingly, the writ petition is dismissed and is. All right. One more thing, I said before you say that, further, in the case of Bonnet, Ispat and Energy Limited, Personal Unit of India, 2012, 11 1. Report, no, no, and in the case of state of Rajasthan and others versus Sharwat Kumar Kumawat 2023 live law package 2580 has been held. No person has any fundamental right. No person can claim any right for mining purpose. Action number 30 process. We have asked to obtain instruction whether the correction of the things in previous license process. Otherwise, item number 19 was. Here, doctor, I have not received the instruction, but you, by 2 o'clock you receive, will wait for you. 2 o'clock, you have got 1 hour to ask. It is probably. It's still there. Huh? Still there. But it's still there. Okay. I can. So, okay. It's still there. So, okay. Definitely, next week, okay. But today, I. 2013, not next week. Next week, why next week? Okay. Okay, okay, okay. I run the pair of it, right? That is adjourned for a week. This is the matter afternoon. Okay. I think I think. Wait for me. Wait for me. I think this again. Yes. Long gets it.
where the government of India announced an industrial policy on 2007. It was defined at page 42.
Page 42.
Fine. Apart from the other incentives, but it was defined at page 42. Government of India has approved a package of fiscal incentive and other concessions for the northeastern region, namely the Northeast Industrial Policy, effective from 1/4/2007, which entail the following. Now, duration is also fixed. All new units as well as the existing units which go for substantial expansion, unless otherwise specified, and which commences commercial production within 10 years period from the date of commencement, from the contribution of also will be eligible for incentive for a period of 10 years from the date of the commencement of commercial production. Whether a new unit or an existing unit which undertakes substantial expansion in 10 years from the and which commercial production within 10 years from the date of the effective of the notification shall be entitled to the incentive for a period 10 years from the date of commencement of the project. Now we'll also find at page 45. Page 45.
Yes.
Transport subsidy scheme below, the bottom in the 40. Yes. The transport subsidy scheme could continue beyond 31/3/2007 on the same terms and conditions. However, an early evaluation of the scheme will be carried out with a view to conducting necessary safeguards of to prevent possible leakage and misuse. So that the transport subsidy scheme was to continue beyond 31/3/2007. However, it was provided that an early evaluation be made for the purpose of necessary safeguards for to prevent possible leakage and misuse. The safe transport subsidy scheme will also find it page 30.
Yes.
Now, my lord, being expired by the provisions made in the industrial policy. Additional, my lord, took steps for the establishment of a cement grinding unit.
Yes.
And at page 47, my lord, the petitioner was granted certificate of registration under the industrial policy. Page 47.
What is the date?
Well, look,
27th, so there's no date. What is this? 847.
page 47, my lord, 19/3/2009.
It's so bad. 2009.
9.
I think big.
At the bottom, on the left hand side.
Ah.
Guwahati, date, it was issued on Milord 29/3, but it was dated 19.
Yes.
So thereafter, page 48, the consent to establish the industry unit was granted by the state 24.
It's 48. 48. It's the consent to establish.
Right.
It is 379. Give it by whom?
By the Pollution Control Board account. What is the register for central excise station? Step, you know.
Yes.
There is page 56, you know, other Assam rate cap, registration.
That road.
Where, that,
That for the registration.
that will register.
It is
So it is effective from 2nd June 2009.
Yes.
Then at page 58, you know, it is about the Assam Anti Tax Act. It is from the same date, you know, that is 2nd June.
Assam VAT Act.
Assam Anti Tax Act, page 58.
Assam
Anti Tax Act.
with effect from
This is the same date, of the 2nd June 2009.
That-
Then at page 60, the petitioner got registered under the Central Sales Tax Act. By registration dated 5th June 2009. Page 16.
CST registry.
Mile.
This is
This is dated 5th June 2009. The page 61, the petition was granted the registration and license to work at the factory by the government of Assam. It is 13/1/2012.
it isn't granted to P. Prem Kumar Ajanta. What
My
is
lord.
it?
It is given to the by name. The appeal licensing basis cement manufacturing company.
Occupier of.
My lord.
So how does this have any relevance?
That is the cement manufacturing company which is before also. That is the license was granted. I'm just specific.
License for granted for what?
For
work-
factory.
for
Work at the factory.
operating the factory. Okay.
Then at page 62. The sanction of the power load was given by the power department government of Assam.
So how does this have any relevance?
So this relevance is only that the establishment of the industrial unit. It was complete prior to the amendment. Bill.
Page 62 is the,
This is dated 18th February 2012.
what is it?
This is a power load sanction
Overload sanction.
by law.
Eighteen one,
By law.
Yes.
Then at page 64, the registration under the transport subsidy scheme.
yes,
The power load was given. Sanction below. The petitioner also was ready to start the production in the third quarter of the year 2012. But since the commercial production was delayed because the power connection load was not given, and that got delayed, and thereafter the petitioner could start it's on 31/1/2013. In the meantime, the freight subsidy scheme was introduced. All my.
Yes.
Now, in the meantime, the freight subsidy scheme was introduced on 2013,
23.
22/1/2013.
The freight subsidy scheme.
My lord,
It replaced the earlier scheme.
my lord. And to mention, that industry unit which start commercial production after the notification of the sale scheme will be governed by the new scheme.
Where is that page?
Page 67.
This scheme may be called some of the state of publication is the.
My lord, my lord. Thereafter, you'll find.
When was it published in the official gazette?
It is official gazette, my lord. It was published on the official gazette on
22/1/30.
my lord.
Yes.
In page 68, you'll also see. New industry unit. New industry unit means an industry unit where manufacturing activity has commenced on or after the date of publication of the scheme in the official gazette. So this scheme will be applicable to the respect of the industry unit who have started the commercial production after the publication of the said scheme, that is 22/1/2023. Now, the fourth submission which I am looking for, Dr. That the petitioner having established industry unit on the basis of the provision made in the industrial policy of 2007 and invested huge amount of money in it. And the policy having provided for the transport subsidy scheme will be applicable, although an endeavors have been made to make changes for decades of or vestige of the money. The said scheme of the freight subsidy scheme cannot be made applicable in respect of the industrial unit who has completed the establishment of the industrial unit prior to framing of the said scheme by virtue of the industrial policy of 2007. Now, before placing before lordship, I will not place number of judgments to the judgment. I may take your lordship to the position of what ground the applicant or the purpose of.
So basically, your, you, as per the freight subsidy scheme. There is no subsidy for fly ash.
Right.
But in the earlier transport subsidy scheme of 71, there was a subsidy for fly ash. Now the NEIPP, that is a different thing.
Right.
The NEIPP that you said, that's a different thing. The NEIPP came only in 2007. The transport subsidy was there in 71. So what is why do you bring in that NEIPP?
In NEIPP, mentioned that the state scheme will be applicable after 31/3/2007 also.
Okay.
That's in the policy, no? In the industrial policy. We kindly also will see case
42.
Page 45. It's not 42. So there was industrial policy 97 also. There also the same was agreed. Page 45, you know?
Yes.
Clause 14. The transport subsidy scheme to continue beyond 31/3/2007 on the same terms and conditions. Therefore, however, an early evaluation of the scheme will be carried out with a view to introducing necessary safeguards to prevent possible leakage and misuse. So without the state transport subsidy scheme will continue, although an early indication is made for introducing necessary safeguards for the purpose of preventing possible leakage and misuse.
This transport subsidy scheme, how do we know that it refers to the 1971 transport subsidy scheme?
Because there is only one transport subsidy.
Now, why is fly ash so important?
So that is major raw material
That's a bigger problem.
for the pilot.
But what is the component of cement? Right?
That's the question, what is the proportion? We mentioned that is a major raw material.
Bigger problem. And where do you get it from?
It is outside also because the transport subsidy scheme is for the
Why out of home? You are giving the transport subsidy scheme. Whatever, but where is the source?
transport subsidy scheme.
No, the source of this fly ash.
It's thermal power projects, usually thermal power,
So from where to get it from?
thermal power project. Because they use the coal, from coal that
From
comes,
coal.
yeah, it's from the coal.
Is there any thermal power project in Northeast?
So even if Northeast is there, then also from the Northeast also, the internal movement from the place to the
No,
factory.
no,
Well, I will take it.
I just want to know from where do
I will give you a lot of where they get. I will also make, I will see that the reasons which have been given in the FNO. So I paid the judgment.
So you mean, when did you started production on
31
31?
3/2030.
See,
After 8 days of the coming to vote for this.
31, 330.
Right.
Thirty-one, 3 or 31, 1.
31 3 because I just answered you. It's just- What one? I but after 8 days. I did it.
So the transport subsidy scheme, ended
On 20 from 22/1 to 2030.
on 22, 1.
Right.
So by a few days.
I said it. Now the question is, according to the doctor. There is no dispute that the framing of the scheme is very not dispute at all. But but the change of policy cannot take away the vested rights of the industrial unit, which is accrued on the basis of the promises made in the industrial policy.
But the change of policy,
Change of policy.
but the change of policy. Not change policy. That's right.
By law, on the basis of the promises made in the industrial policy.
Of the promises made.
Right.
The promises made.
In the industrial policy. Now, there was also seen the clause that for the purpose of even to indicate the vestige of that one, they can take steps. It is also. But the effect of the state, they must place before the court the how vestige and in what way the vestige was there, it was there, that must be there. The effect of the state, that the state cannot resile from the promises made.
Yes.
And they must place very heavy materials before the court to show that such a public interest was involved, that they have to change the policy. Now, we'll also seen that the transport subsidy scheme was there, and the only ground which was given that prevention of wastage and leakage of the. Now, whether in their epidemic, they have demonstrated to the court that there was any wastage and leakage of revenue, and in what manner it was there, because the FFO directly said below in judgment that saying only wastage will not do. You have to place facts and figures before the court to show how wastage and leakage of revenue are there. Now, wastage and leakage of revenue will only be there when somebody is misusing the scheme. Instead of 5 years, somebody bringing something else.
But what about the state? The key thing is there. Only thing is that the subsidy that we're giving now is to somewhere taking away the subsidy that even this. Other than
No, that means that, you made a promise that your transport subsidy will be available to you with all the. Now, on the basis of that promise, I established the industrial unit. After the industrial unit has been established, one part today 5 years is there. Assuming, Atman said, they could have said cement industry itself will not take. They could have said. They can do it in respect of the industrial unit which gets established. They have to take effective step after the announcement of the trade subsidy scheme. But the industrial unit which had already been established on the basis of the promises made, that cannot be taken away. They have all rights to frame the policy. And any person who will come for investment will know that, yes, it will not be available. We may establish, we may not establish. It will be open eyes which will come. But after making a promise, and thereafter, after the industrial unit takes all the effective steps, makes the investment, everything, thereafter to say that this you will not be entitled to. So that goes against the doctrine of communist purpose, which has been laid down by the Supreme Court as that I for the first.
Okay, suppose you have 50% of your. Then what happens?
So it is the effective step for the establishment of industry. Now the court will consider whether effective steps have been taken or not. Because the effect of says that if it can be anti-status can be granted, the petitioner can be put to the back to the same position. You can do it. But if the petitioner cannot be put to the same position where it was there earlier, prior to establishment, then you can't do it. In the
So
actual-
what you want right now?
Right.
Suppose if we allow the expectation. And we say, okay, he has to be given subsidy for the supplier. That means everyone is against it.
No, those, your office, those will not come before your office. Now,
But then the supplier has subsidy, we carry on how long?
well, it is 10 years from the date of the commencement of production. So for 12 years, from 2012 it started. That production started 13.
For 10 years.
23 it will end, 23 it ended.
Steaming also already withdrawn.
I understand what I'm saying. I totally said that trade subsidy scheme has withdrawn the transport subsidy.
That's great.
So the trade subsidy scheme also has been withdrawn.
It-
For the limited period, whatever is there, that is only that period.
The problem is now. It's about by
8 days. Now, well, when the
suppose you have built the park say by 8 years, then what would happen?
8 years,
For 8 years doesn't make a difference.
the question is that so I told from how the production has not started from this date. One cannot say that for the production has been started within 10 years. Before 2017, the production must start. The policy said it started 1/4/2007. And commencement of production must be within 10 years.
Okay, as per the
Policy.
as per the NEIIP.
By law. So
That's
one,
it.
one must start before 10 years.
But the transport subsidies of 1971 does not come under the NEIP.
NEI promised that transport subsidy, whatever was there, that it will
It
be given.
continue. But doesn't say till when it will continue.
No, it will continue for the 10 years is there, period is there, that they will be entitled to the benefits under the scheme for 10 years from the date of commencement of the production. Whatever benefits have been given in the scheme,
No, I agree. But then if that transport subsidy is not tied up with this NEIPP.
will be tied up with it.
It is tied up, but then the NEIPP is for 10 years. Transport is not for 10 years.
But transport subsidy scheme, the period is not there.
Not there.
Now, by the trade subsidy scheme, they replaced it. I think out of made for 5 years or something. Trade
It's been
subsidy.
made 5 years and the 2016 that has been withdrawn.
Withdrawn.
The 2013 scheme. It has been withdrawn in 2013 already. Beyond that, before expiry, yes, before expiry.
So the question is that they can withdraw transport subsidy scheme, they can withdraw capital subsidy scheme, nobody can stop them. But the question is that whether you by way of withdrawing, you can take away the promises which have been made. Now, only one word, one line, except that they change the policy, in the fleet, what are they saying? And may I read well, okay?
is page 129. It starts from the W, it starts from page 127. Paragraph 7 below. That with regard to the stating paragraph 3 to 5 of the petition, the deponent begs to state that the erstwhile transport subsidy scheme has been extended beyond 31/3/2007 with the approval of the Cabinet Committee on Economic Affairs. And while approving its extension, the CCA directed that an early evaluation of the scheme will be carried out. Now, Your Honor, after evaluation of the scheme, Your Honor, only read the words. The evaluation will be carried out for the purpose of wastage and leakage of revenue. After evaluation of the scheme, a note was moved for the consideration of the CCA, which approved revision and modification of the transport subsidy scheme 1971 by another scheme, namely the freight subsidy scheme so and so. The revised scheme applicable to all the units which commence commercial production on or after the date of notification of the scheme. Those units which are not started the commercial production, their claim prior to the effective date of the notification of the scheme. As per the revised scheme, freight subsidy is inadmissible on the transportation of fly ash, which has been placed in the negative list. The decision to place fly ash so in the negative list had been taken after careful thought and consideration, which is neither arbitrary nor irrational and alleged by the petitioner. Who says that the government of India is taking irrational arbitrary? I'm saying that your decision is very fine. But so far as I am concerned, you cannot take it. Now, what you were seeing below, they have missed the word. Early evaluation will be made for what? You have seen the policy. For prevention of leakage and wastage. Now, I will place what decision for. If I place the decision for the communist problem.
He'll be coming. I'm appearing for the state, so I have limited role. But since I am also like India, I mean, basically we are the implementing state. So I have also state republic. So I'll make my. I'll make my.
It is not their policy also. Don't think it, there are 31 members. Other grounds for the purpose of public interest is nothing. Details, namely that there are two methods of credit provided for the amendment and the actual consumption as energy consumption has been reduced based on the calculation of energy charges per kg from 24 to 26. There has been large scale theft of that unit were closing down, and there was no mala-fide intention on the manner of revocation of the notification, and the cost of production of power has gone up by rupees 24 per unit are consideration, which hardly involve any public interest. They were more of the nature of the losses which they have been suffered by the corporation, and these methods were evolved to reduce and make good the losses. Restructuring benefits to so in part the factors which are aimed to make the losses good for the corporation. This is not the case in which serious public repercussions are involved. These are not the factors which they put together constitute public interest. Theft of the electricity was approved by Cogent data, and that as a result of giving the benefit to the entrepreneurs, the hill areas, they were misusing it or there was theft.
of energy at a large scale by these persons to whom the concession has been given, then of course such factors, if all data were brought to the record of oath, could have persuaded the court to get a different view of the matter. But simply because there was theft of energy, the state cannot persuade us to hold that the revocation of such concessions can be held to be in public interest. Since the benefit was given to those units in the hill area, there should have been overwhelming evidence to show some bona fide on the part of the consumers, which have persuaded the corporation to revoke it. If there was no misuse of electric energy by those units in the hill area to whom the concession has been granted, that in that case, it cannot be taken that there was really public interest involved which persuaded the corporation to revoke it. No person can be permitted to misuse the concession or benefit and invoke promise estoppel. Promise estoppel is not one-sided affair, it is rather two-sided affair. If one party abuses the concession, that it is always open to the other party to revoke such concession. But if one party avails the benefit and is acting on the same representation made by other party, then the other party who has granted the said benefit cannot revoke the same under the grab of public interest. Therefore, the grounds that the revocation notification was issued to public interest and the same of the favor of the state cannot persuade it to be content. It is true that a detailed statement was given in the previous paragraph of the written statement filed by the Acting Corporation before the Allahabad High Court, and unfortunately, the High Court did not advert to these details raised by the saying to. I think did not persuade us to take a contrary view from the view taken by the High Court. There is no claim saying that the public interest is paramount and private interest has been sacrificed for larger interest. But after putting all these cases on the subject, the judicial consensus that emerges that whenever the state has made representation to public, and the public has acted on the representation and suffered penalty, and therefore there is, in that case, the state is stopped from presenting the benefit, the detriment of the people except in public interest or against the state. So far as public interest has involved the case concerned, we have found that there was no overwhelming evidence to revoke the benefit granted to the industry in the area. So far as the specific from the High Court, paragraph 55.
This is not to public interest.
Well, they must say that the public interest on the factors. The lawsuit has seen two words, theft and misuse. Now, they have nowhere said that anything theft was there, any misuse was there. But there are 35 minutes.
Yes.
In this 21st century, when there is global economy, the question of trade is very important. The government offers for the benefits to attract the independent act on the benefits they offer. Thereafter, the government withdraw these benefits. This will seriously affect the credibility of the government and so the short-sightedness of the government. Therefore, in order to keep the faith of the people, the government or institutions should abide by their commitment. In this context, the action taken by the corporation in reversing the benefits given to independence in the areas will sadly reflect their credibility and people will not take the word of the government. That will shake the faith of the people in the government. Therefore, in order to keep the faith and maintain good government is necessary. Then whatever recognition made by the government and economically, which induces the other party to act, the government should be not be permitted to withdraw from that. This is the matter of faith. Otherwise, what will happen, Melody? You say that, please come. We'll give this to you. Some industry come on the basis of that. After they establish, they say that, no, will not become. We withdraw. So you make a representation, a promise, that if you do this, you will be entitled to these benefits. And after the person takes the effective steps on the basis of that promise, so that promise cannot be withdrawn, except overriding public interest And that's what I will tell just let me know. What is the overriding conclusion is that the court has said that change of policy is not a factor which will affect the promise which is made.
Another big bunch.
You must be ready, otherwise all are not necessary. But you don't know what architect will be replaced before what's. Yes. So there are 19.
There are 19.
I don't. Yes. 1 minute. Stays below. What is the doctrine of province proper? There are 19 at page 29.
It's 29.
Right.
Yes.
See on the basis of how it started, I will not burden a lot. Right?
Yes.
I will come to the page 33.
Yes.
Paragraph 23.
Yes.
It was also contended on behalf of the government that if the government were held bound by the every representation made by it regarding intention, when the exporters of effect in the manner they were expected to act, the result would be that the government would be bound by a contractual obligation, even though no formal contract in the manner required by Article 299 was executed. But this contention was negative, and it was pointed out by this court that the respondents are not seeking to impose a contractual right, they are seeking to impose compliance with the obligation which is there in the Textile Commissioner by terms of the scheme. And we are of the view that even if the scheme is executive character, the respondents who were aggrieved because of the failure to carry out the terms of the scheme were entitled to the court and claimed that the obligation imposed upon the Textile Commissioner by the scheme be ordered to be carried out. It was thus laid down that the party who was acting in the lines of the promise made by the government altered its position, entitled to impose the promise against the government, even though the promise is not in the form of the formal contract as defined by Article 99, and the article does not mitigate that is the applicability of the doctrine of provision. Let's come to paragraph in the page 34.
Yes.
We take a look to the last 5 lines. What is the government? What if the government makes such a promise and the promisee acts in reliance upon it and utters its position? There is no reason why the government should not be compelled to make such promise like any other private individual. The law cannot acquire legitimacy and gain social acceptance unless it records with the moral values of the society, and the constant endeavor of the court and the legislature must therefore be to close the gap between law and morality and bring about its near an appropriation between the two as possible. The doctrine of promise couple is significant judicial contribution in that direction, but it is necessary to point out that since the doctrine of promise couple is an equitable doctrine, it must help when the equity is so required. If it can be shown to the government by the government that having regard to the facts they have transpired, it would be inequitable to hold the government to the promise made by it. The court could not raise an equity in favor of the promisee and impose the promise against the government. The doctrine of promise couple could be displaced in such a case because on the facts equity would require that the government should be held bound by the promising made. When the government is able to show that in view of the facts as have transpired since the making of the promise, public interest would be prejudiced if the government were required to carry out the promise, the court would have to balance the public interest in the government carrying out the promise made by citizens, which had induced the citizen to set up and after position to and likely suffer the promise were required to carry it out by the government and determine when the equity fits. It would not be enough for the government just to say that the public interest requires that the government should not be compelled to carry out the promise. The public interest to suffer if the government were required to carry out. The government cannot, as Sajay pointed out so and so, claim to be exempt from the liability to carry out the promise on some indefinite or undisclosed ground of necessity or expediency, nor can on as the ex parte appraisement of the circumstances. If the government wants to resist the liability, it will have to disclose to the court what are the facts and circumstances on account of which the government claims it to be exempt from the liability and could be for the court to decide whether those facts and circumstances on account of which the government claims to be exempt from the liability, and it would be for the court to decide whether those facts and circumstances are such as to consider if a change of policy would not a government. Mere change of policy would not be sufficient to exonerate the government from the liability. The government would have to show what precisely is the change policy and also the reasons and justifications so that the court can judge for itself whether which way the equity, the public interest lies and what the equity of the case demands. It is only if the court is satisfied proper and on proper adequate materials placed by the government that overriding public interest, you also specified, requires the government should not be held bound by the promise placed before the so and so that the overriding public interest required the government should not be held bound by the promise and could be one could be free from the unfettered court would so and so. That lordship will see the last line, but court would insist the last three words of the page. A highly rigorous standard of proof in discharge of this burden. I will often see paragraph 33 at page 43. The state, however, contended that the doctrine of promise table has no application in the present case because the appellant did not suffer and detriment by acting on the representation made by the government. The Banaspati factory set up by the appellant was quite a profitable concern, and there was no prejudice caused to the appellant. This contention of the state is clearly unsustainable and must be rejected. We do not think it necessary in order to attack the appellant doctrine promise table. The promising acting in reliance on the promise should suffer and detriment. What is necessary only that the promise should have altered its position on reliance on the promise. The promisee, the position was impliedly accepted by Denning in Toronto when the knowledge had pointed out that the promise must one which was intended to create legal necessity and this to the knowledge of the person making the promise was going to be acted upon by the person to whom it was made and which was in fact acted upon. If a promise is acted upon, such action in law is must necessarily result in the alteration of the position. This was again dictated by Lord Denning in Toronto, where the learned Lord made it clear that the alteration of the position only means that he must have been led to act differently from what he would have otherwise have done. And if you study the cases in which the doctrine has been applied, you will see that all that is required is that one should have acted on the belief induced by the other party. Discount Simons also in Toronto, the gist of the equity lies the fact that one party has
by conduct led the other party to change alter his position. This judgment of control in some cases could be found to be depend likewise on the fundamental findings of the alteration of position. In the same way, said to that Lord Cohen. Then again, in showing so, the equity is however subject to the disqualification. At page 45. Last 8 or 10 lines. It is true that taxation is a sovereign of the government function, but for reasons which we have already discussed, no distinction can be made between the exercise of the sovereign of the government function and a trading or business activity. No distinction can be made between the exercise of the sovereign of government function and a trading or business activity of the government. So far as the kind of the government, whatever be the nature of function, if the government is done, the government is subject to the rule of public property. And if essentially ingrained in of this rule are satisfied, the government can be compelled to carry out the promise made by it. We are therefore of the view that in the present case, the government was bound to exempt the petitioner from payment of sales tax with respect of sales to property affected in the case of surplus for a period of 3 years from the date of the petition.
Issue here is slightly different. Out here it appears that the government has said that we give it to you, provided you complete your enough production.
In the first, it is permitted.
Okay, it was only the NEI.
It was said that 10 years from the date of the commencement of the production. It was never said that you start the commercial production. It said you start the commercial production in 10 years from the
NEIP.
NEI. So 1/4 becomes 7, 10 years becomes 17. Before that, you have to start the commercial production. Then you will get 10 years from the date of the commencement of the production. It was not so Miller that you will, first of all, a particular date is there. So I will establish the industry unit.
Okay, what about the transport subsidy of 1971? Prior to the 1997 also, what did it say?
So prior to 1997, the transport scheme 71.
What did it say? What was the clauses there? What did it say? How because out there, fly ash was supposed to be given transport subsidy.
Right.
Now that transport subsidy was to be for how long?
So that is
In the 71 transport subsidy.
the policy I will explain.
Page 32.
Well,
For a period of 5 years.
right. It was extended from time to time.
For a period of 5 years.
The policy was from time to time extended. And this policy was in the 97 industrial policy also on the basis that the transport subsidy 71, the transport subsidy was granted. And perhaps the respondents will also dispute that if the commencement of production could have been prior to 22-1, you would have been entitled to the transport subsidy on the basis of transport subsidy scheme. Assuming that instead of 31, I would have started on 21st. There would have been no dispute. Because the 5 years, the freight subsidy scheme
only says that from the date that it is notified, after that, the commencement of production.
But the period of 5 years that has been provided in the transport subsidy scheme, that has not been altered by the NEIP scheme of 2000.
So that transport subsidy scheme, always the amendments are there, I let them to say. It was always extended from time to time. Back in 97, 10 years period was there. 10 years the transport subsidy was granted. From 97 to 2007, 10 years earlier industrial policy was there. There the transport subsidy was granted. There is no dispute about it. Prior to this policy, there was another policy, it's effective from 1/4/1997, which expired on 31/3/2007. There also the transport subsidy was available.
So you see, when you go to the NEIP scheme
Right.
at page 45.
Right.
It speaks of the coverage,
Right.
page 40.
Page 42, yes. I will just again read, here, the bottom paragraph. Yes, standard for date of commercial production, that's what I'm saying.
No, I'm not on that. I'm talking about this OF of 1st April 2007.
You'll also see page
See the
42,
coverage.
page 42.
Coverage is coverage. NEIP scheme 97 announced that the covered services will also be included. New industrial policy scheme and scheme investment subsidy scheme 2002, central cooperative insurance scheme 2002. So it covers only this coverage. Don't be percent.
Transport subsidy scheme,
Transport subsidy scheme, no doubt, is mentioned in
there are 45,
Around.
15.
para 14. What I'm trying to say is that it appears that the terms and conditions put in the NIPP scheme is covering these things. That is then the coverage. But does not appear to be, this tentative thing, does not appear to be covering the provisions of the transport subsidy scheme, which has its own provision.
Right. That's my understanding because the same provision, 97 was there. Policy. And the transport subsidy was granted on the basis of that 97 scheme.
Ah.
It was the 97 policy. The transport subsidy was granted.
No, I'm not saying that the transport subsidy goes. It is still there when the NEIP scheme is there, 97 of 2007. But the duration of the transport subsidy scheme, that will be given as per the transport subsidy scheme.
But the duration has been extended from time to time.
So
Otherwise,
let us see that.
otherwise, I would say, where subsidy scheme we say that this will not be applicable.
Huh?
Where subsidy scheme says.
Yes.
The
The fly ash will not be applicable.
from the date of the framing of the first subsidy scheme, the transport subsidy scheme will not be there.
Ah.
If the transport subsidy scheme is not there, it's there for 5 years only. Then there will
No. I'm on this. I want to know what was but according to you, if you are eligible to be given the transport subsidy scheme, you should be given for 10 years, according to you. But the transport subsidy scheme itself says that it's only for 5 years.
I will take
That,
the notification by which was extended from date to date. From date 21 to every time it has been extended. And made applicable.
No, I'm not on that. It's just-
So, yeah, Lordship, I was saying that transport subsidy scheme says 5 years. The policy I'm saying 10 years.
the transport.
The reason is that, I may just try to explain.
See, this So what I'm saying is that the scheme will be there forever. Will be there, I mean, for number of years. But the,
For 5 years.
but the subsidy part will be given only for 5 years.
Right.
That's, yes, yes,
Act in industrial policy, like,
yes,
the transport subsidy scheme was operated
already there.
was only for 5 years.
Correct.
Without industrial policy.
Correct.
Without industrial policy, anybody was availing the transport subsidy scheme, it was for 5 years.
Yes.
But if the industrial policy says that the transport subsidy scheme, same scheme will be applicable for the industry, and it will go for 10 years, then irrespective if the industrial policy is not there prior to 97, then only 5 years on the basis of transport subsidy scheme. But you say that the benefits which have been given in the policy will be for 10 years. You also see there, 10 years from the date of the commencement of the production. Once again, if you lost it, good. I will take you lost it once again. Duration,
Yeah.
at page 42. All new units as well as existing units will go for substantial expansion unless otherwise specified in Commerce Department within the year period from the date of notification, but it will be eligible for the incentive for a period of 10 years from the date of commercial production. Now, incentives have been given in the later part. It starts with like para 5 excise exemption, income tax exemption, capital investment, interest subsidy, compulsory insurance, incentive by way of service, other so-and-so industries, incentive by power generating units, incentive by hacking, so-and-so establishment, so-and-so, value addition, transport subsidy scheme.
I think the 1997,
I have not got, but I will place it.
I think I will have to put the
I'll place. And you'll also kindly see me at page 64 once again. This registration under the transport subsidy scheme was given on 31/3/2012.
So that was all right. That is not a,
No, 97 policy,
then I think that I think that
yes, that is because in the policy, you have to make an people also at a case. Page 46, The new industrial policy and other concessions in the northeastern region announced on memo number 24/12/97 will cease to be operative with effect from 1/4/2007. Industries which have commenced production before 31/3/2007 will continue to get the benefits under NEIPC 97.
I want the 1970
Uncertainty.
correlate with the
By the
1971.
that what was there in the about transport. Uncertainty.
How would you go that way?
So these are all on the promised total,
All of the stuff.
all promised total.
So your basic case is probably or stopper that has that gateway delay because the bar to get it done.
Because I have already said this in the thing, fellow effect for the doctor say that basically a thing not backed up by the industrial policy can be withdrawn at any time. But an exemption granted on the basis of the industrial policy that cannot be withdrawn before on the basis of the property score. Because on the exception,
Okay, where does it say?
I don't,
Where does it say that?
but I, obviously, I think I can do. Seven.
Huh?
Page 27. The second part at page 39.
Page?
39.
Okay.
Right. For I am attend the IIT minutes there are 24 at page 40. Right? Page 47, the IIT I will get. There are 27, 24.
47.
24, page 47.
Yeah.
Consequently,
Yeah.
it cannot be held on the clear recital found in the aforesaid notification issued by the board that no representation whatsoever granting 10% rebate in the electricity consumption bills could be called out from the notification. We therefore agree with the finding of the High Court that these notifications of the board had clearly held a promise to the new industries, and these new industries had admittedly got established in the region whereby the board was operating, acting on the promise the same on the equity and of the board. Such a promise was not contrary to the statutory provision, but on the contrary was in compliance with the direction issued in the section so and so. These new industries which got attracted to the region, relying on the promise, and altered their position so and so. They had spent large amount of the money by establishing the infrastructure, had entered into agreement with the board for supply of electricity, therefore had necessarily altered so and so. Therefore,
Okay, I think, here's the other side.
All the judgment side, but the different part, the judgment side, the text, and in two people, faculty, the judgment and the different part, okay, coming from top. So, whatever judgments are there, paragraph, will make it convenient, that makes it perfect.
Don't be too much. There's no point. You have typically around 8 candidates on provisionally
So
established.
what happens, states that, when people go to bar, all arms and ammunition is available. You may use one or two, but arms can be available, because that is required, can be used.
That's true. But there is too much for some.
I'm not covered at all.
You will get bogged down with the.
So I just think that two paragraph of every judgment, because the judgments are big, so the relevant part of two pages.
Not the relevant part.
Only relevant part I expect.
Yeah, you take this back. They give the people a bit. I mean, as it is so bulky.
In fact, one more is there, I'm not giving to those. Giving books become difficult for us for every time.
This is not it.
So far as I have here. Each case, primary, just what promissory expense.
That's right.
Now, what was the promise told out to? If we may look into page 42 of the section,
842.
page 42, the office memorandum dated March 4, 2007. Now, Rashid will appreciate while reading a law judgment or a memorandum, we do not take out one sentence if we do it. Okay. Another is the state of our subject. We have to read it as a. Now, Rashid has seen the coverage. My senior was on the duration. That is two. All new units as well as the existing units which go in for expansion unless otherwise specified and which commences commercial production within a 10 years period from the date of dedication of this instant OF will be eligible for incentive for a period of 10 years from the date of commencement of commercial production. Logic report. Here, my senior's client has commenced commercial production at 1/1/2000. But let us read further. Transport system. Although the transport subsidies was very long before 1971. Transport subsidy scheme has taken to of this government. And what it says, the transport subsidy scheme would continue beyond 31 2007 on the same terms and conditions. However, an early evaluation of the scheme will be carried out with a view to implementing necessary safeguards to prevent possible leakages and extreme. And in the next page, my senior has referred to two, the 53.
Yes.
The government reserves the right to modify any part of the policy. Now, this was not a promise per se, because of industrial policy subject to evaluation. It can be determined by the government at any point of time. It is not an open promise given to the petition that we are bound to give you this. Because the language itself says that it can be modified. It can be modified. And so far as Worship, for purpose of giving incentives is concerned, that is not just to upgrade his profits. Incentives are not for the purpose only to enhance the profit of the particular company. It is to expand industrialization. That is perhaps a case which my senior has thought before this another thought. I will give a this lawsuit, this was a tax matter, where, it was, Jai Bhagwan Oil Floor Mill. And there's another case of Chief Shakti Floor Mill, also those were related to tax, because related rate of this honorable court has held. We are of the opinion that the transport subsidy received by the SSC during the assessment year so and so is intended to stimulate industrial activity in backward region. To generate employment opportunities and to bring about development in the state, and it is not meant to provide higher profit for the state. It's not profit oriented, it's just looking to bring the industrial activity in this part of the country. Now, as it is lordship, I would submit the scheme of this OM dated 1st April 2007 does not in any matter hold out any promise to any. You're welcome to set up an industry, but it also makes it very clear that this is subject to evaluation. It also comes with a rider that the government may modify the scheme in the public interest. Now, why the government has put fly action for negative? He is more concerned with that. Now, that is not a unilateral decision taken by a single person. I take your lordship to paragraph 7 of my affidavit. That is third page of my
Running page.
one page. It's not 120. 129.
But the 127.
It starts at 120. Referring to page 120. Parasite. If I may read. That with regard to the statements made in paragraph number 3 to 5 of the petition. The important text states that the erstwhile transport subsidy scheme was last extended beyond 31/3/2007 with the approval of the Cabinet Committee on Economic Affairs. And while approving the extension, the CCPA directed that early evaluation of the scheme will be carried out. After evaluation of the scheme, a note was made for the consideration of the CCPA, which approved revision and modification of DSS 1971 by another scheme, namely Trade Subsidy Scheme 2030. The revised scheme is applicable to all those units which commence production on or after the date of participation of the scheme, or those units which did not submit any claim prior to the effective date of the notification of the revised scheme. As per the revised scheme, trade subsidy is inapplicable on transportation of fly ash, which has been placed in a negative list. The decision to place fly ash in the negative list has been taken after careful thought and consideration, which is neither arbitrary nor irrational as alleged by the petitioner. Now, if I may take your lordship to paragraph 70. Paragraph. Paragraph.
Paragraph?
Paragraph. Okay.
Yes.
Now, with respect to the statements made in paragraph 13 and 14 of the petition, the default text stated it was earlier proposed that the total amount of transportation cost eligible for transport subsidy for any raw material finished product shall be subject to maximum of 50% of the value of the particular raw material finished product, which was not agreed to by the beneficiary states. So it was proposed to disallow subsidy on transportation of fly ash from outside NER as this material, as this material is of low value but high volume. Transportation of such huge bulky material from outside NER over long distances need to be discouraged in order to promote more efficient business models necessary for self-sustenance of the industry. It calls for modernization of the industry. Then paragraph 14 was. But with regard to the statements made in paragraph 18 and 19 of the writ petition, the department begs to state, reiterate that a conscious decision was taken to disallow subsidy of fly ash from outside NER, as this material is of low value but of high volume, and the transportation of such bulky material over long distances needs to be discouraged in order to promote more efficient business model. Therefore, Lordship, it is not only setting up of industry. With time, that has to modernize. Until and unless a check is put, it will go in the same way as it is going on. That you'll also just appreciate for a moment. This is a industry totally for people. If I am not wrong, the brand is Hyundai. Now, if I do not know whether your lordship has ever gone to North Bengal, sometimes seen because while traveling to the Bangkok for some case over 10 years, what I have noticed is all the materials come in from outside. Cement is more expensive here than in North Bengal. It goes from here. It goes from here, we pay more, they pay less. They pay less. Now, should not these industries take a modern tax? Of bulky material lordship, which is as per the affidavit, which value is very low.
What's the component of cement?
What is that? I they consume 33% of it. 30% of the whole book. That's what I have.
Google won't do that. Did Google tell you that?
Give the detail, I have read something. 30 people.
See, there are a lot of cement factories after area. And they buy area.
Very, yes.
Yes, just for using
Yes. Yes.
One of the major components is
Like,
light. So I want to know what is the what percentage of fire
very good.
now to get into that space where there is no rail yet. Fire. There should be a problem. तो सब देते हैं but just maybe they will do it.
It has to go back.
But
They wanted the cement industry to come up. This is the put up the cement industry negativity. They will not give at all. And who will come? In the Birmingham and all those people have come only for that. They will get subsidy and benefits. No businessman.
that's the big thing. Actually, I want to reach the goal also, that we are working on. So everything is like,
No, no, so I, from the, from the policy plastic, I would come to that. No promise has been told out. No, no, no problem. That these case has been, it's only that there has been a. Now, the policy itself makes it very clear. I cannot take out one word from there to substantiate my. The review, power of review is there because it says the specific.
one thing is, what is the judgment you were saying in this?
Oh, that was. I have got a copy for myself. That 2017 one GLJ segment.
2017 one PSP,
GLJ
PLJ,
25
259, Tara,
25 in my.
25. Any other,
There lots of other case of the Supreme Court has also been. Yeah, everywhere, Otila Padampak you notify. Jai Bhagwan oil and flow. Otila Padampak you find everywhere. So, was it, even those cases, the cases relied upon by ICC are matters relating to tax. No, no, no. No, I place all electricity I am placing for lordship, no tax. No. Electricity I have also judgment, and I will not place all these judgments. Now it seems that I will have to place all judgments. Yes, because my learned friend saying industrial policy, there is no promise, I will place that one also. That the reserving of the right to modify.
It's just a promise, as just a promise, industrial policy is a promise.
Yes.
Maybe
Lots of see. Page 168. There are two, three judgments of this other court also I will say. That's also industrial policy. Page 168, the relevant part, page 173. There are 7. Coming to the second question, namely the issuance of notification by the state government in exercise of the powers under section 7 of the Bihar Finance Act, it is true that issuance of the notification entitles the industrial units to avail the incentives and benefits announced by the state government in its own industrial policy. But in exercise of such power, it would not be permissible for the state government to deny any benefit which is otherwise available to an industrial unit under the incentive policy itself. The industrial incentive policy issued by the state government after such policy approved by the cabinet itself. The issuance of notification section 7 of the Finance Act by the state government and finance department, which notification issue of to carry out the objective of the policy decision taken in the industrial policy itself. In this view of the matter, any notification issued by the government order in exercise of the power under section 7 of the Bihar Finance Policy is found to be repugnant to the industrial policy declared by the government election, that the same declaration must be held to be paid to that extent. So whatever has been said in the industrial policy, you can't go beyond that. And in incentive law, the appellate court has said, what is the case about? It says that, I'm just, that's the thing. The two case, there are, why you are saying, there are many things are there, not kept.
No, but just how you said that the industrial policy. What's the difference? The industrial policy with the.
All of industrial policy like says that exemption is there. Now, a notification has been issued by the state government in the exercise of the power of the sales tax act. Now, the Supreme Court said, by exercising the power under the sales tax act, you cannot curtail or go against the industrial policy. Industrial policy, whatever I'm entitled to, you cannot go and continue to that. If any notification is issued, which overrides or is contrary to the industrial policy, that will be back to that extent. And recently, not 2 years back, the Supreme Court said that even if industrial policy announced, even if you don't issue the notification, on the basis of the industrial policy itself, the benefit will be granted.
What was the word in it that there will be industrial policy about to?
The promise below, the promise is an incentive which are announced by industrial policy, is a promise, and the right accrued on the person promisee to whom the promise is made.
Anyway, we'll have to see.
There are three court judgments of this on the court also, you know. There is the,
You give me the.
I request somebody also, you know.
Oh, it's prepare somebody. You prepare the thoroughly.
I'll prepare, you know, so that it becomes easier, you know. Which in this case, Apex Court also said, you know, such restrictions and conditions that can be imposed, is mentioned there in the policy, that will not empower to go against the policy. And in this case, my learned friend said modify the policy, where the policy has been amended, policy has not been amended. You may be great, you may, which people have taken a decision, you take. But you cannot just take a decision and thereafter, on the one hand, he says, come, and on the other hand, he says, now, kata baga, don't give. That you cannot do. Which businessman will establish the industrial unit in the interior areas unless and until he gets benefit? That is for the purpose of encouraging.
It's half given to the side.
Meghalaya also is there, not here also it is there. Meghalaya cement is there.
Half given to zero.
Here also, Assam also. And thereafter, Dalmia is there in Meghalaya. Why they have gone there? To get the benefit.
No, one thing is lime is there.
Well, lime is also there, lime is available other places. So in West Bengal also, the cement industries are there, cement industries are everywhere.
Anyway, you. Oh, 13 man.
With an open eyes, you promise me something, and thereafter you say that, no, we will modernize it. You modernize in future, who stop you? After his facing the law, whatever policy you may take, who stop them to find the policy? You know? We could have read the policy before, but not at our cost. Not at our cost.
Okay, so one thing is I want that 1997.
The policy will not what is the percentage of the IAS in this one, and whether industrial policy, on the basis of industrial policy promise is made or not, whether the clause, the reservation, reserve the right to modify, whether that would take away the, well, on 4-5 points, my limit is given, but I find out all those points. I'll just point out one spot. I
Yes.
don't have much role to play here, but one small point of it.
One small point. Usually,
It is a small point, but it's a small point. I will not elaborate that. Just, I'll just take your lordship to page 64.
just a minute.
So whether any promise was made to him, whether really any promise was made to him, whether he is eligible for any promise.
Just a Just let me find out my note.
He is not made any promise by he is making. You have not made it public. He- I'm just supporting his, community support. I am from a state.
No, not that. Not that. Not that. It's my fault.
Community forum and-
No. This is the cost. Yeah, that's the cost.
Last time also, it was displayed.
As based on, as written down now, it has to be covered.
No, in the comparison, you know.
No, it is here, it is. Yes.
Before my limited start, to note in the planning note, the promise was not made by him. Promise was made by Mr. Akhilesh Chaudhary. And a person who has not made a promise, how he can say that the promise, defending the promise? He has no role. It's a legal
That-
point, Lord.
that-
See, it's a
No,
legal
not
point.
legal point.
It's a legal point. It's there in the policy. I'm just assisting your lordship whether there was any promise made or not.
Correct.
The lordship will find page 64, lordship under transport subsidy scheme. If you want to avail transport subsidy, then you'll have to register yourself under the scheme. Transport
So
subsidy.
he was registered.
So he has registered, lordship, and they may kindly have a look, page 64.
Yes.
So the lordship will find there that this is a registration given by the industries department. State of Assam, and this is the state department,
Just a second.
page 64.
You want. Registration,
Registration under 50%, 75%, 90% transport subsidy scheme.
given by. Industry department.
Correct.
Government of- Yes.
So now, lordship, now there, the serial number 1,
Yes.
is very important. It says the date of commencement of commercial production, original as well as after expansion is proposed. Is it lordship got it? It's
Yes.
serial number 1. So it's proposed, lordship. They haven't gone for commercial production as yet. So they have registered and they want to go after some point of time, they will go for commercial production.
Correct.
Correct. Now lordship will turn to page 32 of the scheme, Lord. The transport subsidy scheme. Who are eligible?
So. It's 32.
32.
Yes.
So point number 3, lordship. So which are the industries which will be covered by the scheme? So under this scheme, which are the industries which are being given any promise if at all? So 3, lordship will find
Yes.
is applicable to all industrial units bearing so and so, both in public and private sectors, irrespective of their size in the selected areas A, B, C, D, for a period of 5 years from the date of commencement of commercial production. So what makes you eligible for promise? It's the commercial product.
Correct.
It's not establishment or you have taken some steps to establish. I will promise you, I have promised you only when you have done your commercial production. So this industrial unit has admittedly gone for commercial production on 31/1/2013.
Yes.
And by that time, lordship, this transport subsidy scheme is not there at all. has gone.
I hate this.
Yes, no, lordship, like, yes, the 22/1/2013, the new scheme has come. So this scheme is not there. So there is no provision under this scheme. So you can't say that, like, you have been, I have made you, made any promise to you. Because you are not qualified under that. Because we haven't gone for commercial protection. Now in industry, you can start up an industry, like setting up a unit. But it may take long years, but it doesn't mean that doesn't qualify you. You'll have to first go for commercial protection, then only you can be qualified for transport subsidy scheme. So this 71 scheme is not, there is no promise made by this 71 scheme to him at all. Because he is not qualified under this 71 scheme. Because by the time he has gone for commercial protection, his scheme is no longer there. Now, whatever promise that has been made under the trade subsidy scheme only, 2015. And 2013 scheme says you are not allowed for flyers. So this is what like small point lordship I was trying to make out. And lordship, one case law lordship that as far as promissory estoppel is concerned, the two cases are there. I will rely. Right. Let's say that 2023 1 SSC 386 Hero Motor
One is
Hero Motor Corp case. Uh, 386. So lots of the promissory estoppel, lots of the concept of promissory estoppel has evolved from Motilal Bottom Part. But it's a long duration of period and it has been evolving day by day.
so which para?
So para 64, para 64 lordship will find that Motilal Bottom Part has been discussed in this case.
So what does it eventually say?
It eventually says like a government policy. If there is a government policy, there is no aspect. If it is for public good, if it is for the public good,
Right.
if it is a public good.
Para?
Lordship, from para 64 onwards,
Where is the relevant portion?
Lordship, para 64, I'll just read out wherein Lordship is Motilal Bottom Part and Godfrey Phillips has been discussed. Para 64. It could thus be, Lordship has got it, page 413. It could thus be seen that there is some discord in the judgments of this court in Motilal Bottom Part Sugar Mills and Godfrey Phillips on one hand and Jeet Ram Sri Kumar on the other hand. Then they discuss this 65. This court in Motilal Bottom Part Mills Company holds that if on the basis of promise made by the government, the entity changes its legal position to its detriment, the state would not be permitted to resile from the said promise. It is to be noted that the said judgment is authored by Bhagavati judge and the bench strength is of two learned judges. And page para 64 lordship, within a period of 2 years, Kailasam judge in Jeet Ram Kumar found fault with some observations made in Motilal Bottom Part Sugar Mills Company and held that the observations made in Motilal Bottom Part Sugar Mills were not in tune with the judgments of the constitution benches in M. Ramanatha Pillai and Gwalior Rayon Silk Manufacturing Company and the judgment of 4-judge bench of this court in Ramkumar. Then lordship will find page 68 lordship. Then if they discuss about this discord, then para 68. However, a common trait in all these judgments that could be noticed is that all these judgments consistently hold that there can be no estoppel against legislature in exercise of its legislative function. There is no qualification given in this paragraph. The Constitution bench in M. Ramanatha Pillai has approved the view in American jurisprudence that the doctrine of estoppel will not be applied against the state in its governmental, public, and sovereign capacity. It further held that only exception with regard to the applicability of the doctrine of estoppel is where it is necessary to prevent fraud and manifest injustice. The analysis of all the judgments of this court on the issue would reveal that it is a consistent view of this court, reiterated again in Dr. Phillips, that there can be no promissory estoppel against legislature in exercise of its legislative functions. Undisputedly, notification dated so and so withdrawing the exemption notifications was issued in pursuance of statutory mandate as provided under so and so act. If the contention as raised by the appellants is to be accepted, it would make the provisions under section so and so CGST Act redundant and autoid. The legislature in its wisdom has specifically incorporated provisos so and so, providing therein that any tax exemption granted as an incentive against investment through a notification shall not continue as privilege if the said notification is rescinded. If the contention is accepted, it will amount to enforcing a representation made in the said OM dated so and so and 2003 notification contrary to the legislative incorporation in the proviso to section so and so act. In other words, it will permit an estoppel to be operated against legislative functions of the parliament. We are therefore of the considered view that the claim of the appellants on estoppel is without merit and deserves to be rejected. It is further noted that the court has also consistently held that when an exemption granted earlier is withdrawn by subsequent notification based on a change of policy, even in such cases, doctrine of the promissory estoppel could not be invoked. It has been consistently held that where the change of policy is in the larger public interest, the state cannot be prevented from withdrawing an incentive which it had granted through an earlier notification. Reliance in this respect could be placed on the judgments of this court in Kanishka Trading versus Union of India, Fiji Sales Corporation versus Union of India, State of Rajasthan versus Mahavir Oil Industries, Sidwali Skills Limited versus State of UP, and DZ Foreign Trade versus Connect Exports. Then look at paragraph 71, wherein the Unicorn Industries was also discussed. Recently, this court in Unicorn Industries, after surveying the earlier judgments of this court on the issue, has observed thus, it could thus be seen that it is more than well settled that the exemption granted, even when the notification granting exemption prescribed for a particular period in which it is available, can be withdrawn by the state if it is found that such a withdrawal is in public interest. In such a case, a larger public interest would outweigh the individual interest, if any. In such a case, even the doctrine of promissory estoppel would not come to the rescue of the persons claiming exemptions and compel the state not to resile from its promise if the act of the state is found to be in public interest to do so. We are therefore of the considered view that even on the ground of change of policy, which is in public interest, or in view of the change in the statutory regime itself on account of GST Act being introduced as in the instant case, it will not be correct to hold the union bound by the representation made by it, that is the whole trade. So here, let's see what Biden Act the provision was supposed to have been made, but because it has been changed, but it says like as far as like, the public policy is concerned, that a provision estoppel is not applicable at all.
How long would you take?
That's all. Another case of the unicorn case has been discussed, so that otherwise, Lord, the affidavit has been filed by my colleague, so that has been what public interest.
So what is the other judgment with it? Citation?
That citation, Lord, another one is, Lord, that unicorn, that is 2019 10 SSC 575.
575, para,
Para, Lordship 13 to 15
and then
and 16 to 20, 25, 26, and 37. 25, 26, and 37.
25,
26
26,
and 37.
and 30. Okay.
No, I have a copy of it. I want to put it. So in my humble submission, was that concept of Motilal Padampat that has been diluted to a larger extent by this recent judgments of Hero Motor Company. So after this judgment,
the Supreme Court judgment had come, I think. That Motilal Parampa judgment is still there, and that is the law to be taken.
Anyway, so we'll fix another date. I guess, therefore, you give me all the things, then we'll put it.
And I will also look to prepare a summary.
Yes,
and
yes.
even part-
Just, I've heard basically everything. But I don't know when he'll give me this. Uh, uh, this is the matter on. Next week. That's it. Oh, fine.
So Thursday, there is a series, 50 series of it.
21.
Twenty-eight, no?
Huh?
28.
28.
So prior to that,
Wednesday, 28.
বন্ধু আছে তো। কোনটায় বন্ধ? You need to go to second. The second is fine.
So this is
But you also need to pass it
this is the matter on Thursday and Friday.
move from 3 courts
Ah,
to the Wednesday.
yes. It's,
One more matter, you also heard it length in interest supplemental.
ah,
And that went to 3 courts and you have mentioned again and again.
which one?
The interest supplemental, you also heard it length.
Ah,
And but was not mentioned part of court.
okay, okay.
So it went to 3 courts and we have to mention it that it was the detailed order is there of the
It's come again, yeah.
now it will come.
Now it will come again. And the other matter also,
That is still implanted.
ah, and,
I was questioning myself, my lord, that why you have not considered that intervenor should be there.
ah,
The same thing which he's arguing, he's already arguing unnecessary.
even I was thinking, I should have allowed him to intervene. Not impleaded, but intervene.
I was also thinking that I should have considered that let him be intervenor. What he will argue, he's already arguing the other side, he's arguing the same thing. And what benefit will be there? From there, it will come that assuming that let him-
But it might be, it might be a blessing in disguise for you also. That time that 1 year period will go.
not 1 year period, but the BPCL will be in trouble, they will have to run. Because they will not be able to about the work.
Anyway, there also I had made quite a long order
You also passed the order,
already.
and in fact, you also, but almost if your hearing was complete,
Yes, there was something was required from me,
only something.
from
both
the
sides are arguing.
respondent. Anyway, happens.
I think for the lawyers, the benefit some lawyers and Supreme Court.
Always get the benefit.